My lord, may I be permitted to mention restitution application?
My lord, may I be permitted to mention one matter, my lord? Your lordship was heard this matter on thrice occasion, and your lordship was pleased to give liberty to me to file a supplementary evidence. And I have given supplementary evidence also. My lord, this short matter, my lord, let it.
Other side.
My lord, join to the. I will inform. My
Your Lordship, may I be permitted to mention a matter? Your Lordship, this is a restoration application.
My lord, may I be Lordship kindly leave to mention, my lord, two correction of your Lordship's order, some typography.
Have you annexed the order?
Yes, yes, I have annexed the order.
Which matter?
Very short. Only the similar matter, same issue, you'll also decide on last occasion. Number the correction is only of the name of the post and
Name of the post.
name of the post.
To be mentioned tomorrow.
High কোটেই আছে, high কোটেই আছে,
Lordship, may I be permitted to mention one matter?
high কোটেই আছে.
Yes.
Lordship, this is a restoration application, Your Lordship.
Why is it inactive section? Inactive.
এই যে, এখানে তো আর কেউ তো দিলেন না তো?
Lordship, I beg to appear on behalf of the petitioner, my lord.
And for the commission.
There are just small typographical corrections, my lord, if I may kindly indicate. At page number 1 of the order, my lord. The second last.
Give your, that is mark. Your order, or
And
earlier that you.
I had
got
handed
it?
over on the last occasion, my lord. I'll just, doesn't matter. it is.
Okay, you tell.
Yeah.
That's not confidential.
It is,
It
it is a mark. correct. Your Honor, if I may kindly indicate the second last line, it should be dated 21st 12/2011. Instead of that, it is written 21 and 12 and 2011. That is one correction. Your Honor, may kindly please come to page number 3. It is the 4th paragraph. Notification dated, it should be 23rd 12/2011.
1, 2, 3, 4.
penultimate paragraph.
Penultimate paragraph. 4th line from top. 23rd 12/2011 it should be.
It would be
2011 instead of 2001.
sorry. Yeah, 2011.
Your Honor, then on page 5.
আচ্ছা, আপনি এদিকে আসুন স্যার। By reason of typographical error in the second last line of page number 1, it is one date has been erroneously recorded as 21 and 12 2011 invited comma মধ্যে, which should be recorded as 21.12/2011.
I'm grateful.
আচ্ছা, in page 3, আচ্ছা, page 1 of the order dated 2nd April 2000, page 3, in 4th line of the 4th paragraph, the date has been the date has been it has been recorded as notification dated 23rd/12/2001 instead of notification dated 23rd/12/2011.
I'm grateful.
Next,
Lordship, it's on page 5, paragraph 1, the first paragraph, page 5, the second last line. More than 66 marks it is written.
এইটা petition number 1
No, it should be 64.
ওটা হবে না?
page, oh,
It should be 64 because the last candidate who had got in the general category was 64.
আচ্ছা, in the
এইটা
second
হবে,
last
সবাই তো
line
একই
of
ক্যাটাগরি না, ওটা দেখ, ওটা
page
বেঙ্গলি
number
পাস।
এটা ঠিক লিখেছে বাবা।
হ্যাঁ
5,
ঠিক আছে, আমি পড়েছি।
the number have been erroneously recorded as 66 in place of
ও আগে মনে আছে
64. And
Instead of 66, it would be 64.
uh,
And Your Honor, would kindly take up page 10.
then,
You know, since it's a long order, maybe some
Where-
typographical
where-
errors have crept in.
my fault.
No, no.
Yes,
Your Honor,
page 10,
page 10, the very first line,
Uh.
the
Oh.
commission by 450th instead of 405. It
actually,
would-
in page 10, in the first line, it has been erroneously recorded that invited the commission in its 40 THQ, 405তম meeting, invited comma close, instead of the commission in its 450th meeting.
50th.
That's
I-
all.
That is all. If I may, since my learned friend is already there, I had also communicated to him. Your Honor, if Your Honor may kindly take up the last paragraph of page 10. Last paragraph of page 10.
Yes.
There is no error. I just want a small insertion if it commences, Your Honor. In view of the foregoing analysis, it is held that petitioner number 1, 4, and 5 who offered their candidature for the post under pass category is entitled to get 6 marks against training qualification. Resultantly, the commission is directed to award 6 marks in favor of the petitioner 1, 4, and 5, provided they have secured 55 and above marks in their training courses. It is found that the petitioner number 1, 4, and 5 have secured higher marks than the last selected candidate in their category. The commission, now this is the portion, the commission shall take next following actions in accordance with law as urgently as possible, or else they'll keep it pending, Your Honor. That is the only as urgently as possible, or within a period of 1 month.
it will amount to modification. I don't
No,
have any objection.
Your Honor,
This is
because
not
Your
correction,
Honor,
this is my
Your
interest.
Honor may kindly see, we have been waiting for 10 years, more than 10 years in this. Only a small
Not
insertion.
be in the circumstances you should have filed, it would not be. It is not a typographical error or anything.
It's a small, since my
If-
learned,
If no time limit is fixed, then it would be deemed that the time would be reasonable time.
Yes, yes.
I'm grateful, Your Honor. We all know that,
Honorable
Your Honor, but the way the
My
respondent.
lord, it is not required, my lord. My lord, we will, my lord,
Okay,
process it
Mr.
expeditious.
Bondapathyay will take care of.
My lord, my lord.
If my learned senior
My
friend.
lord, all
says
other
that-
candidates, they have been, my lord, treated and, my lord, proceeded expeditiously, and these petitioners will also. হয়ে যাবে।
I'm grateful, Your Honor.
Great.
Acha, office is directed to effect necessary correction accordingly.
I'm grateful, Your Honor.
এইটা রাখবো? হ্যাঁ? নতুন আছে? আমার নেই দাদা। সেখান থেকে নেবো।
My lord, item 2, my lord, I am for the respondents, my lord, your lordship was, the hearing has been concluded, your lordship. was-
Hearing concluded, but today
Yes.
most probably
My lord,
both of you stated that you will submit the written argument.
my lord, that is ready, my lord. I am playing short pass over, my lord.
Okay.
My lord, I appear for the respondent authorities.
Lordship, I appear for the petitioner, Lordship. My senior is engaged in court number 13. Kindly, I am praying for not to do, your Lordship. Kindly give it tomorrow.
My lord, kindly give it on Friday then, not tomorrow.
Friday, my senior will not be here.
Ashish থাকবে না? My lord, keeps it tomorrow, let us say
Tomorrow.
we'll come back.
Okay, not today.
Gratefully, Lordship.
Lordships, I am appearing on view of the state, your lordships. All the occasion hearing concluded, issued short notes of written argument, your lordships.
You have prepared a short note
Yes,
of
may I
argument.
submit?
You have served.
Well, I have received
yes,
this
sir,
argument.
your lordships.
Well, I am also, there is a back seat, it has not been typed it out. In course of the day, within 5 minutes, I am giving it to your lordships. Lordship record it, like that.
So I am to read, so judgment deserved, I have no
Yes, yes.
alternative. Okay.
I remind your lordships what has happened. This is in case of the organizing teaching. No, your
The
lordship
person
remember?
has retired.
So, yeah, I retired. So, so far, my lord, his continuation is concerns, my lord, it is admitted positions. But they said the step pattern doesn't fit. We have taken a point that the post, if the post is lying vacant till today, well, that post has not been filled up. To show, my lord, I am entitled to have that benefit from the date of, because the earlier decision of the our High Court was that the organizing teachers will have no claim. Now, my lord, the last judgment, I have annexed that in the writ petition, last judgment which has been delivered by the other division bench, relying the Monimnath Sinha and Shitikana Adhikari. Normally, it was tested by my client before the Honorable Apex Court. Apex Court set aside the order and my lord directed to accord approvals. And your lordships remember that the Nagendranath Das, Nagendranath Rai, your lordships delivered the judgment. There was a dispute of the non-teaching staffs in the name. A lordships was pleased to hold that no approval should be given in terms of the Supreme Court judgment. They have also admitted that, but they said the Supreme Court judgment is under 142. The question of 142 or 141 doesn't arise. Supreme Court never says that it will not be applicable to other places. It is principle has been laid down to show, my lord, earlier division bench judgment has been considered, has been set aside. This is the, where, my lord, the continuation of the petition, it is admitted positions. And only the step pattern doesn't fit. If the posting question is lying vacant, if I am worked there till my retirement, why should I deprive from my pay? This is the only issue.
Well, in the order of Honorable Justice Pranab Chatterjee, as the lordship then was, it was specifically mentioned that the administrator observed in his report. Later on, that administrator by giving a written
Right,
statement, stated that I have not.
I have not given.
Even headmaster stated that no, he would not work.
Yes.
He would come at an interval of 3
No,
months.
he
4
is
months.
not presently working. Headmaster said he was there, but he is not, his occasionally is coming. This
Occasionally
is
is
the,
coming.
occasionally is coming.
Ah.
Well, organizing teachers and appointment of recruitment rule doesn't arise in respect of the organizing teachers. That has been held by our division bench also. And you also knows that if a organizing teacher, why the questions of following the recruitment rule? Recruitment rule following, Malay, it question crops up because when the post is sanctioned, prior permission is given by the DI. Then, my lord, the exchange authority inviting name from the employment exchange, these are the followed by the recruitment. But the organizing teacher means I joined the school from the very day of inception. And after approving the recognition granted by the board, I accrue some right. So, revision bench earlier view was no, you have no right because this is the administrative circular, other things are there. And the division bench order was continued.
Organizing managing committee has no power to give recruitment.
Yes. But my humble submission before your lordships, that when the organizing schools is there, administration, it is admitted that they have been rendering their services. So shows they should not be deprived. That Supreme Court says so in view of the latest judgment of the Supreme Court. So show your lordships consider all these things, deliver the judgment. I have prepared my lord,
The parties have concluded their respective arguments and even they have submitted their written arguments on behalf of their respective,
Respondent number 134.
on behalf of petition. The judgment is up.
আচ্ছা।
So you give your written.
ইমিডিয়েটলি উইদিন 2 মিনিটস, উইদিন 2 মিনিটস আমি এখনই দিয়ে দিচ্ছি, ও সেলাই করছে।
আচ্ছা।
যা বাঁচা গেল, যা হলো।
পাঁচ আছে।
হুম?
পাঁচ আছে। পাঁচটা শুধু ভাটিয়ে দাও।
হ্যাঁ 5টা কি করবো?
My lord, 5 in this matter, my lord. We are referring for the school authority. Mrs. Maiti is leading me through online, my lord.
Mr. Samanta was directed to take instruction. Today on merit, I shall not argue. Only the question that she is continuing his work without salary till 3 months salary was given and thereafter no further salary was given. Mr. Samanta was directed to take instruction as to what is the present position, whether the petitioner is working or not. The school authority is there. I believe he will not deny that I am not working there.
Milord, your lordship, kindly allow me to submit, Milord, on behalf of the school authority, Milord. Pursuant to your lordship direction, Milord, I have already filed my affidavit in opposition to the writ petition, and copy also has been supplied to my learned friend, writ petitioner. So, Milord, let there be an order of Milord filing a reply to the opposition. I do not know whether Mr. Bari will file any reply or not.
Yes, yes, fine. You are responding number 4.
My lord, I have filed, but my learned friend, writ petitioner,
My lord,
They have
I
not
shall
filed the
argue on
reply.
merit in next day. Your lordship kindly direct why the payment was not given by the DI. Still he is working there. Interim order was there.
but that has to be stated on oath, then. That has to be stated on oath.
One affidavit in reply to the affidavit in opposition filed by respondent number 4 is on record. It has been filed.
Yes. My lord,
It has been
we have
filed by
filed.
the petitioner.
We have filed.
Now facts remains that I have
তোমাদের তো দিয়ে দাও, রেকর্ড আছে?
forgot the matter. What
না,
content,
আপনি রিপ্লাই দিয়েছেন, রিপ্লাইটা তো পাইনি আমরা।
রিপ্লাই তোমাকে দেয়নি কপি? রিপ্লাই কপি দাও না?
But the
Mr. Bari
copy of,
just recapitulate the matter.
দিয়ে দাও।
my lord, the copy of the reply has not been, my lord, served upon us, my lord.
Oh,
Copy of the reply, because we have filed already the affidavit in opposition on behalf of the respondent number 4, my lord. Already it is submitted before the honorable, before your lordship.
My lord, the copy of the reply, if it is not served, I shall serve by tomorrow. Today his brief is not traceable, it is not with me. Only, my lord, your lordship kindly fix up next day for final disposal or hearing. In the meantime, why the payment was not given in spite of the direction of the court? Only 3 months salary was given. Contempt application initially was there, it was disposed of behind my back. Still he is continuing. Why the payment is not given? Court directed they go on paying. Why payment was not given? Mr. Samanta was directed to take instruction. কবেকার অর্ডার ছিল ওটা দেখেছি? এই এটা জাস্টিস জ্যোতির্ময় ভট্টাচার্য অর্ডার 2011, 2011 Justice Bhattacharya, Jyotirmoy Bhattacharya, as his lordship then was, passed an order. আছে গো তোমাদের কাছে অর্ডার কপিটা?
এখানে নেই, দেখতে পাচ্ছেন। এই কপিটার মধ্যে নেই।
অর্ডার কপিটা?
oh,
Samanta
is
sahab,
this
আছে কাছে?
matter that caste certificate,
Yes, yes.
Yes, yes.
Yes, caste certificate.
SDO cancelled the. caste
SDO
certificate.
cancel. Whether the power of the SDO is there, whether the scrutiny verification or scrutiny committee will cancel the certificate, that is the
Or
sub.
the writ petition is at all maintainable also. Whether writ petition itself is maintainable or not.
That you cannot take this point at the final hearing.
No,
This is first time I am appearing. I have filed my opposition.
school authority dismissed your service.
No, the complaint, Malad, I was appointed following the recruitment rule in the reserve category, producing reserve certificate. The certificate, genuinity of the certificate is not questioned here. The one organization of the scheduled caste organization, third party, my
Made a complaint and on the
Lord,
basis
a
of that
complaint that
complaint,
there is a fourth certificate.
SDO
Fourth
cancelled.
certificate.
SDO initiated.
SDO inquired, the SDO said, it is not a fourth certificate, but the certificate, it ought not to have been issued. So it is being cancelled. In terms of the SDO's decision, the school authority cancelled my appointment. Immediately I rushed to the court. Court passed an order of a stay.
and directed to go on paying the salary because I was in service. So that's why, my lord, that still I am there. There is no dispute about my continuation, but one of the salary is not being paid.
Where is that order?
Order of Justice
That-
Bhattacharya, your lordship, kindly. I'm sorry, my lord, today I am without brief. Kindly excuse me, my lord. ওখানে হয়ে যাবে না তো?
No, record speaks that on 16th March 2011,
Yes, Justice Bhattacharya's order.
Justice Tandon. Justice Tandon.
Justice Jyotirmoy Bhattacharya initially passed on.
Pass an interim order restraining the respondents from giving effect or further effect to the impugn order. Impugn order, that means the cancellation of your appeal.
Yes, yes. And
Till
Justice,
5 weeks from date or until further. order.
thereafter, Justice,
Whether the said order was extended.
yes, my lord, Justice Bhattacharya's order was there.
Yes.
এই সমস্ত সাহেব আছে না কাছে কপিটা? অর্ডারের কপিটা দিয়েছিলাম না?
অর্ডার কপি দিয়েছিলেন একটা না?
নেই আমার কাছে অ্যাপ্লিকেশন ফাইল করার জন্য সেই এতে করা হয়েছে।
Lordship got it.
No, Justice Bhattacharya also observed that you two sets of, you have joined,
Yes.
there is a joinder of cause of action.
My lord, a contempt application was taken out by my management client, my lord, and that was been disposed of.
Behind my back.
You did not appear for which court is not responsible.
কি বলবো, আমাকে যদি রাতে ফোন করে বলে দেয় যে ব্রিফটা ঘরে পাঠানো হয়েছে হয়েছে।
On 1st November 2011, the interim order was extended for a week. Interim order which was passed earlier will continue for a week. Interim order will continue until further. order.
Yes.
On 8th September 2011. Have you made any application seeking a direction for release of salary?
সেটা কি ডিসপোজড হয়ে গেছে?
No such application. You have filed a contempt application.
No, that was disposed of. I
That
was
has
not
been
there.
disposed
I failed to appear. The submitted order has been complied with.
So the allegation of violation of any order passed in this petition has not been accepted by the court.
No, no, violation was there. They said they have paid that. They have paid that. But the fact remains, when I have been working there, why the payment is not being made? There is no interruption of my service. Why the payment is there? That direction, my lord, the Mr. Samanto can,
You are discharging.
I'm discharging my duty till date.
In view of that interim order,
Yes,
but without any
without
payment.
salary.
So what do you want? Only
No,
you want
definitely.
discharging duty and taking salary or get the matter disposed?
No, no.
You lordship kindly dispose of the matter, my lord. Finally, it should be disposed of.
Finally,
2011 matter, my lord, your lordship.
I am a candidate discharging my full duty. Can you withhold my salary? You have not taken any steps for variation of the interim order. You have not taken any steps for filing an appeal against the order of the interim order passed by the London single judge. It is continuing. Why you are withholding my salary?
Lord, first of all, I cannot apprise your lordship regarding anything. I have been served with only the writ petition and the order regarding the contempt and all these things. I am hearing these words first time for this matter. Whether contempt was there, order was there, complaints were there. I am not aware of anything.
However, gist of the case is that the petitioner was appointed assistant teacher.
No, no.
No.
The group D staff.
He approved the staff against the vacancy schedule reserved for SC candidate.
Yes.
Now subsequently,
Yes, you cancelled it.
SC caste certificate was cancelled. Following such cancellation, his appointment was also cancelled by the school authority.
Yes.
But
No,
by
yeah.
dint of one interim order passed in this matter, he is claiming that she is still, he or she is still discharging her duties. But you are not paying her salary.
Only instruction I got received from the DI Jhargram, my lord, that she is going there and signing the attendance register and coming back. Only oral instruction, my lord, but the papers I received, there is no authenticity in those papers, my lord, because it's through WhatsApp, no seal and signature, nothing is there, my lord.
But these factual aspect, it is the school authority will say
Yes.
whether she is coming only to put her signature on the assistant admission attendance register or she is discharging any duties or not.
Madam, বলো বলতে।
বলো ওসবই বলবে ওসব কিছু কি বলছে
Mr. Maiti,
Mr. Ma-
only allowing her to put her signature on the attendance register.
I shall be taking instruction. I do not know, my lord. I do not know whether she is at all going or not. I shall have to take instruction from the school authority, my lord.
It's not given.
I have taken only this much
I
instruction.
was told, my lord, I was told as per the order passed by the Honorable High Court, my lord, already
authority will
monetary benefit has been already granted to her and she has already withdrawn.
as because the matter is pending
Yes.
court signature
Thereafter, I do not know, my lord. Thereafter, I do not know. I shall have to ask my client.
that salary.
Yes, yes.
Even I am putting my signature in the office of the, I am entitled to have my salary. You cannot withhold my salary.
If subsequently it is found that it is judicially determined that the cancellation of your caste certificate
No, my lord, so long.
as well as the cancellation of your
If it is-
appointment
if
are
it is-
justified,
If it is,
then-
if it is,
then what will you will
Mala,
pay back?
that your lordship knows, Mala, I have nothing to submit. If it is a justified, no, it is a justified cancellation. Till that working, that payment should be made. You cannot deprive my payment.
How can I
Because
realize
I was allowed to continue
pay?
by virtue of
How can I
that.
realize that?
By the courts act, my lord, I may not be suffer. Because you have been allowed to continue, court permitted me to continue. Whenever, when the order is passed, justified, the cancellation justified. Till today, from tomorrow, I shall not get my salary.
Even if
But you
I-
cannot deprive my salary in violation of the Article 21.
My lord, if I am on a wrong footing, if I have not paid the salary, there forums are there.
Oh,
Yes.
very fantastic submission.
Oh,
man.
why-
Contempt, you file contempt
Yeah.
thereafter.
Well,
They,
your
court
lordship,
cannot shut the door of justice, my lord.
no,
But
no, what
factual
happened
aspect.
2 days back, my lord, a contempt application has been filed against the state because the state filed the opposition on the, and it was 2 days delay. That's why a contempt application was took out by the petitioner. This is the position now.
Question of contempt or not contempt doesn't arise. Question whether you are complying the
I'm
court order, you are paying the
My
money or
underlying
not.
submission is I am violating the order
No,
of
no,
the
question of
honorable
not
court.
violation. We are before the court of law. Whether you are paying money or
Action was
not.
For payment, we have not paid. This is the violation.
Even I do not file a contempt application. Even I do not file a
Then it will be
contempt
decided in the
application.
final hearing.
Where is the order passed in contempt application?
Well, their submitted order has been complied with.
This order.
তো ওইটুকু অ্যামাউন্টটার জন্যই ওটা কমপ্লিট হয়ে গেছে পরেরটা ওরা বলতে কাজ করছে আরে তো আমাদের অ্যাসার্টেন করতে ওরা কাজ করছে ইনস্ট্রাকশন চাই বলে দিচ্ছি ম্যাডাম আছে তো
আমার কাছে ইনস্ট্রাকশন আমি গোয়িং টু
আমার সাইন করতে দেবে না নিশ্চিত সাইন করতে দেয় না সাইন করতে গেলে
You also got it? Order of, possibly order of justice so বসেছে নয় আছে তো এটা হয়ে যাবে করতে দেরি আছে আমাদের কি আছে এটা সই করলে লিভ দিয়েছে সই করে চেঞ্জ করে দেবে সাবমিট রাখলেন
আসুন তো একটু এখানে এরিয়াটা একটা দিন তো
আমাকে যদি না বলে যে লিফট আপনার কাছে আছে কালকে নিয়ে আসুন না আমি কি করি বলো
Now, where is the order? I'm trying to find out the order passed on contempt application. In contempt petition, you raise this issue. you file contempt
But
petition
but so far I remember, they
claiming
submitted,
that the
they
claiming,
submitted their order has been complied with.
claiming
Yes.
that the order has
Only
not
3 months
been
salary was given.
substantially complied with by releasing your
Yes. The
salary.
question is whether the salary is being released or not. It is a continuing violation.
You have not the said order, you have got.
No, my lord, the question is, my lord, I submitted before lordships, unfortunately.
এই দেখুন তো এখানে আছে।
দেন তো একটু আমাদেরকে দেন তো একটু দেখি।
যে
2011 আরেকটা
যে order-টা ইয়ে করলো।
Contempted order.
order of contempt.
That in that order, the contempt application was dismissed or disposed of.
No, this is a
আমাদেরকে দেন,
previous
দেখি।
order 8/9/11.
Oh, 8/9/11, Justice, Honorable Justice Jyotima Bhattacharya
That's Jyotima Bhattacharya.
was pleased to extend the interim order until further order.
My lord.
Now thereafter, non-payment of salary was raised in contempt application.
application that has been disposed of.
Contempt application has been disposed of. So the issue has been dealt with in the contempt
yes,
application.
We have paid the subsequent amount.
Hence, I want to see the order or observation made regarding non-payment of salary in the contempt application.
No.
আমার কাছে আছে মনে হচ্ছে না তো? আচ্ছা পজিশনের মধ্যে annex
My lord, this is the order.
সেইটা দাও না।
Order dated 8th May 2023.
8th May 2023. Give me the copy.
এইটা মনে হচ্ছে দেখুন তো 10/4
13 বার।
না এটা না আরটা দিয়েছি। This order passed by the Honorable Justice Sopashaji Bhattacharya.
তুই ছোট, তুই যাও, আমি যাচ্ছি। বলে দেবে এটা।
No, here direction was given to sub copy.
ওটা নয়।
তার কোনটা ভুল দিয়ে দিয়েছি।
না ও বলে ওনারা বলছেন সব্যসাচী ভট্টাচার্য তাই
না এটা ছিল।
আমার কাছে কিছুই নেই এখানে।
No, both of you are saying that the contempt petition has been dismissed or disposed of.
Oh, stop saying the order has been complied with.
দেখতে পাচ্ছি না আমার কাছে
Possibly, so far my collection is good.
Lord, I find from the report, not the report, the instruction, an amount of 45,165 has been paid
When?
for the period of 1/6/2011 to 8/9/2011.
What was the order?
নেই আমার এইখানে আছে এর কাছে আছে আমার কাছে নেই।
Now, where is the order that contempt application has been disposed of? That order. Where is it? Oh, invoice submission. Yes. July 20th, 2003.
2003. No.
Learned Counsel for the alleged contempt submits that the direction of this
23.
court has already been complied with and hand over the relevant document in this regard, which are kept on record. In view of such submission, the contempt application, the amount in question has already been paid to the petitioner.
2003 or 23, my lord.
Hence, dismissing.
Possibly 23.
23.
Yes.
23. So, show my lord, that is not correct. Whatever it may be.
Payment has been made.
Payment, 3 months payment. Is it a payment? What is the order of Justice Bhattacharya?
That period of payment has been made.
Justice Bhattacharya never said that 3 months payment is required to be made. Justice Bhattacharya just said you have to pay.
Since the amount in question has
What is
already.
the amount?
amount in question.
45,000 is the amount of last my lord, 10 years or
রেট করেছিল সেটাই
I'm discharging my duty.
ছিলাম না।
Your lordship kindly direct the headmaster to appear before your lordships. And if I'm not working, I cannot claim.
No, since you are utilizing her service, exploiting her service.
My lord, we have to
pay.
take instruction whether the my lord, the petitioner has put his signature, whether we have to ascertain this, my lord, we have to take instruction from the school.
Your lordship, my lord, may I submit one thing? Your lordships kindly direct the school authority headmaster to be present if your lordships with the
The headmaster will not present.
attendance.
he will,
It is a fact, my lord, it is a fact. I have been duly discharged.
We are appearing on behalf of the headmaster.
Only to fact that whether the petitioner has been discharging
Certain-
duties or
Yes, yes.
certain-
only
To ascertain
Yes,
whether
yes.
whether he is
Certainly.
discharging his duties
That
or
is my
not.
prayer.
many
That is
other
my
work.
prayer before your lordship. That is
Only
my
up to
prayer.
this.
And if I discharge my duty, if it is appears, your lordship kindly direct to take a steps for releasing the salary in terms of the order of the court. Your lordship kindly direct. If I am not discharging my duty, the question of payment doesn't arise.
Kindly ascertain that whether the fact.
Milord, Milord, at this juncture, Milord, no order may be, your lordship kindly don't pass any order. I have to, Milord, ascertain whether she is working or not, Milord.
Don't
If
pass
she
any
is
order.
not actually working, Milord, question of payment of salary cannot arise at all.
If your lordship direct, if he is, I am serving there, she will register that not to pass any order. If I am serving there, necessary steps should be taken for release
No,
of.
no, there is no document before my lord whether she is working at all. This is your submission, Mayor. This is your submission.
Advocate appearing for the respective parties in course of hearing a confusion arose as to whether the petitioner has been discharging but has been rendering her service in the school or not. Because at a stop, Mrs. Maiti sought placed for a short accommodation to instruction. Stop. In view thereof, leaves the matter for further consideration.
On coming week, any day subject to your lordships. From tomorrow, I have to leave, my lord, from tomorrow. I may be there.
2 weeks since.
Coming week, your lordships, any day subject to your lordships convenient.
Yeah.
No, not on 16, Milord, excepting 16, your lordship.
22. 22.
Grateful to your lords.
Second April, 22nd April.
It will take 14 days.
Yeah.
Fortnight, your lordships. Well, I may pray one further indulgence,
Yes.
if your lord, subject to your lordship's kind approval. The 22nd, if the regular bench sits, we do not know whether the matter will be taken up or not. If your lordships keep it parted, I believe on 22nd on after 3:30 or 4 or 4:15, your lordships can take up this matter. Your lordship your lordship kindly do that.
Okay, it will remain in my.
No, my lordship kindly do that because your lordships will get chance then.
If I don't
Yeah,
desist from
it is a question of livelihood. A scheduled caste candidate, your lordships kindly have a look. He's without money. When he is attending my chambers, I cannot, my lord, keep my tears because of the fact. It is a fact, factually fact. Otherwise, I could not have requested your lordships. Your lordship
It will
kindly.
remain in my list. I am making an effort so that I can sit after giving prior intimation to all of you in the list.
No, if it is a 22nd, your lordship can specify the time. The 4 p.m. Your lordships will take up at 4 p.m. or 4:15, whatever. Within 2 minutes, only this instruction.
Lord, I think on that in that week, I may get some occasion to sit singly. That as and when I think I shall be able to sit singly.
If your lordship sits, no problem.
It will appear.
You are sitting tight over 13 years, 2-3 days.
You are utilizing my service, you will not pay 13 years.
Whether it is at all has to be ascertained. You cannot say.
No time to take instruction.
Okay, yeah.
Tomorrow I am ready to give instruction. By tomorrow?
22nd.
At the time of final hearing, it will utilize it. Okay.
I grateful, deeply obliged to your lords.
6. 12 পরে কেউ appear করেনি। এই দিদি give it এই উনি দিচ্ছেন আইটেম নাম্বার
2, my lord.
2 এ আইটেম নাম্বার 2 এটা ঢুকিয়ে দিন তো। না একটু ডাকতে হবে না ও ডাকতে হবে না আবার টু আপনি ইয়ে করলেন ডাকুন আইটেম নাম্বার 7 ডাকুন কোনটা ও hearing concluded, reserve for judgment. সব নিয়ে যাও বাড়িতে গিয়ে টুকটাক করে এই ওটা খুঁজে পেয়েছেন ওইটা ফাইলটা খুঁজে পেয়েছেন দেখি দেখি ফাইলটা দেখি না 2 নম্বর নয় একটা ফাইল দিয়েছিলাম মনে হচ্ছে হ্যাঁ হ্যাঁ এইটা এই দেখুন এইখানে দিয়ে দিয়েছেন তো আগে দেবেন তারপরে করবে না 500 দিদি আপনি একটু পাশে সরে যান হ্যাঁ তাহলে এই জায়গাটা এসে যাবে আমি ওই ফাইলটা এদিকে সরিয়ে রাখবেন ঠিক আছে নেই নাইন দেখুন তাড়াতাড়ি তাড়াতাড়ি করুন এগুলো ওদের সবকটা সেমই ম্যাটার দিদি দিদি
Lordship, I am for the petitioner led by Mr. Subrodo Mukhopadhyay. I will have to contact with my client's lordship. Kindly adjourn for 2 weeks since it's a matter of 2012.
So on the pair made on behalf of the petitioner, let the matter go out of list.
Out of the list.
with the তলায় লিখে দিই liberty to mention.
Matter may be adjourned for 2 weeks, Lordship. I may contact with my
আচ্ছা, on the plan,
client.
the matter adjourned. The adjourned for 2 weeks. 2 weeks. Right. Yes. 2 weeks adjourned.
13 same, Lordship.
No, no, only thing difference is this.
You couldn't contact the client. Matter has been adjourned for 2 weeks.
No, the police করছিলাম 2 weeks adjourned.
2 weeks adjourn.
You tell what is your fear.
No, no, I leave it to you, my lord. Who am I? Why should I?
No.
When court is of the view that matter should be taken up after 2 weeks,
No, no, no.
I cannot change.
On the fear. It has been written on the fear.
Only thing, kindly allow me 1 minute time, my lord.
Yes.
What happened, my lord, the moment notification was published in respect of primary teacher. Now, NCRT guideline is this, that is mandatory. Those who are trained, they must be absorbed first. But there is no such notification issued by the state of West Bengal for recruiting primary teacher in the year of 2014. That is the pith and substance of the writ petition. Very well, my lord. In the meantime, I shall serve 1 second notice. 2 weeks matter will appear. Naturally, since hearing did not take place, naturally, I am not dared to say, kindly mark it hard in part. I should not. The matter will appear before my lord after 2 weeks. Very well.
Acha,
In the meantime,
in the meantime, the petitioner is directed to convey this order to all the respondents, to all the
Also, my lord,
non-appearing respondents.
I'm praying only one prayer subject to sanction by my lord, that if they have not filed affidavit in the meantime, let them file affidavit. I will not use any reply.
No, direction for filing affidavit has been given. Direction upon them to file affidavit was given.
My lord, right now I am not in a position to recall because old matter, my lord, I cannot. If I go through the file, if not directed, my lord, if your lordship pass this order, my lord.
Order was given.
Very well.
I am informed order direction was given to file affidavit.
No,
If they
not
don't
a
file
single matter.
affidavit, they will face consequence.
Lordship. না না বলছেন কোর্ট অফিসার বলছেন যখন তারপরে কত
নেক্সট
13 or same.
13 সেম মিলার
14.
এই আপনি কি ডাকলেন 11 হলো 12 দেখুন না 11 তো 2 weeks ওটা আবার অর্ডারটা রিকল হয়ে ওটা অ্যাডজন্ড হলো সেই ম্যাটারটাই চলছে ফলো করুন কোর্ট ঠিক আছে এটা হচ্ছে 2 weeks হলো এবার আপনি 12টা ডাক দিন 12টা দিন কাজ করুন না আপনি এসে গুছিয়ে দিন না যাতে ঝটঝট করে তুলতে পারে
My lord's chamber is in this building or there?
Sesquiu Centenary. Yes.
Okay.
Yes. To refund the recovery.
May I leave? My junior will pay same direction. Other matter,
Other matters.
Some other matter also here.
Oh, okay. Didi. Uh-huh. 12 Didi. All 13.
13 minutes same.
Same order. As
Item number 11.
Item number 11.
তুমি বলে দাও তো সাহেবকে অনুমতি নিয়ে আমি চলে যাচ্ছি। মে আই লিভ মি লর্ড?
Yes, yes, yes. দিন 14, হ্যাঁ। আপনারা যখন আজকে লিস্টটা তৈরি করতে It is also your matter. Mr. Mukherjee is appearing in this matter for petitioner.
Next
So-
item number 17, Lordship.
Songita Jana Manna and other.
This matter is
Check,
not.
not today. Check. Item 14, you are not.
Not.
Appointment. Did it? 15.
Lordship, I'm appearing for the respondents. I'm being instructed to appear in the matter, but I have not been briefed yet. Kindly give me 3 weeks' time.
You are not been?
I've not been briefed yet. Did not receive the brief.
You are appearing for respondent. Who is respondent?
Calcutta Rock Labor Board.
Calcutta Dock Labor Board.
Yes.
The petitioner seeking direction for DR, area pension, gratuity, salary of 2007, computation of pension. On earlier occasion, writ petition was filed, appeal was filed. Do you know the facts?
No, I've not received the brief yet.
Asking appeal. Okay, not today, একদিন দেখা যাক, not today রেখে দিন। Not today. Come tomorrow.
Lordship, item number 15 and 16.
And 16?
Yes.
16 same order.
17, Lordship. I am for the petitioner, same as item number 11.
17. Okay, as item number 11.
Adjournment. Seventeen adjourned for 2 weeks.
18 also same player.
18 also.
18 same. Yes.
Oh, petitioner
19.
19. Yes.
19.
I'm appearing for the respondent. But I appear for the petitioners.
DVC.
Yes.
Affidavits are complete. Affidavits are complete.
No, Lordship can hear it out. Because, my lord, this issue has been settled, my lord, by the Honorable Supreme Court of India.
Issue has already been resolved.
No, my lord, that has not been. But that is, my learned friend would obviously be saying it has not been. But my contention is, my lord, 3 other candidates who are similarly circumstanced, my lord, they have been given all their benefits.
Short time may be given, my lord, to file
So
affidavit.
the only determination is whether they can claim parity or not.
Yes, only determination. Only determination.
Issue has been resolved. It is resolved by the Honorable Apex Court. Only issue whether they will be
Whether I can claim parity, my lord, with them.
parity or not.
Yes.
So
My lord,
let him proceed or
my lord, short time may be given to file affidavit, or otherwise, if your lordship so desire, it could be disposed of.
I am not deserved. I have not
Oh, my lord,
entered into the merit.
Yes, my lord.
Enter into let him
Then,
start.
my lord, it is short direction, short direction.
If it is found that only for determination of this issue, your affidavit is required, then affidavit.
Yes, my lord, affidavit. Some records, my lord, has to be brought into, my lord. That.
To show that they are not on the same
They are
footing.
not, they are not.
They are not on the same footing.
Yes.
Only to show that.
But same selection process we participated. My lord, there were 10, my lord, vacancies, 6 for general. My lord, our, my lord, serial number was 5 and 6. 1, 2, and 3 have been given, my lord, all the benefits. My lord, I do not know, my lord, why 5 and 6 will be deprived. The Honorable Supreme Court, if your lordship sees the order of the Honorable Supreme Court.
Okay, you tell the fact.
Lordship. My lord, the post was dozer operator grade 3.
Yes.
Dozer operator grade 3.
Okay.
Now, my lord, a selection, my lord, an advertisement was published by Damodar Valley Corporation. Now, my lord, as per that advertisement, my lord, there were 10 vacancies.
Yes.
My lord, out of those 10 vacancies, my lord, 6 were reserved for general candidates, 2 for scheduled caste candidates, and my lord, 2 for scheduled tribe candidates. Now, my lord, if your lordship, my lord, kindly comes, my lord, to the order of this honorable court, lordship would get that order in the writ petition. My lord, I have a typed copy of that order, my lord, page 20.
Page 20 of the writ petition.
Of the writ petition. My lord, may I place this order, my lord? Every fact will be clear from here.
Yes.
My lord, this is the typed copy, my lord, page, my lord, of this honorable court by my lord Justice M.H.S. Ansari, as his lordship then was.
7 page.
Lordship. My lord, if your lordship has got the typed copy of that order, because my lord, the main order is very illegible. My lord, the original order, my lord, starts from, my lord, page 20. My lord, the typed copy of that order, my lord, is thereafter. My lord, may I place that order? The above writ application is filed by the petitioners, 5 in numbers, claiming reliefs for appointment to the post of dozer operator grade 3. Applications were invited from eligible persons through advertisement number 91 of 18, said to have been published in the Bengali daily newspaper Telegraph, dated 5th May 1991. A copy of the notification is annexure A to the writ petition. The post in question, being 91 of 18, is at serial number 6 of the said notification. The post is of dozer operator grade 3, and the vacancies advertised are vacancy 10, general 6. It's a wrong typing. Scheduled caste is 2 and scheduled tribe is 2. We are not bothered with the scheduled caste and scheduled tribe because we are of general category. The case of the petitioner is that pursuant to the advertisement of the petitioners being eligible and having requisite qualifications applied for the said post and were called for the interview held for the said purpose. The petitioners, it is stated, were selected and placed in the panel of selected candidates, which was prepared in March 1992. The grievance of the petitioners is that the respondent corporation made offers of appointment to certain candidates and thereafter discontinued without filling the vacancies. In the supplementary affidavit filed by the petitioners and affirmed on 30th August 1996, it is stated that there are 26 posts lying vacant for dozer operator apart from certain other posts lying in certain other units totaling in all 32 posts. And that as the panel has not been exhausted, it was contended by the learned counsel for the petitioner that the petitioners can be afforded appointment based upon their selection and impanelment. It must also be noted that here that pursuant to an order of this honorable court dated 24th February 1997, the respondent numbers 5, 6, and 7 were included as party respondents. Now, my lord, 5, 6, and 7 are 3 candidates, my lord, who pursuant to the order of this honorable Supreme Court, my lord, were given the benefits. My lord, they are Gopal Rai, my lord, Trilochan Singh, and Shaheen Akhtar.
No, whether 5, 6, 7 participated in the selection
Yes,
process
my lord, 5, 6, and 7 also participated in the same selection process.
and impaneled.
And impaneled.
You are saying that you are impaneled.
I am impaneled, my lord, we were impaneled, my lord, 5,
What
6.
is the position?
My lord, my position in the panel
Your
was,
position in the panel?
my lord, my position in
Your
the panel.
name, Munna Prasad Singh and
My lord,
others.
Munna Prasad Singh was, my lord, 5 and Gautam Maiti was 6.
Gautam?
Maiti, the second petitioner.
Yes. Your main contention is that the advertisement was issued to fill up 10 vacancies.
10 vacancies, 6
They have
general and 2
filled up
reserve. 4
certain
reserve.
vacancy, but they,
My lord,
they are
they,
not
my lord, they gave appointment to 3 and they were not giving appointment to the rest 2.
they have appointment to 6 candidates,
My lord,
8 candidates.
6 candidates were there. My lord, 1 has not turned up. We do not know why. 3 have been given, my lord, appointment as well as all the benefits from the date of the advertisement.
2 has not been given.
2 have not been given, my lord. These 2 petitioners are before your lordship. And my lord, these honorable
Now,
court,
who went to Honorable
my
Supreme?
lord, these respondent numbers 5, 6, and 7, Gopal Rai, Shaheen Akhtar, and Trilochan Singh. They went up to the Honorable Supreme Court. Because, my lord, they had filed a separate set of writ petition, my lord, challenging the same selection process. My lord, if your lordship, my lord, lordship would find a
Their
supplement.
claim is that they have they had been working for not less than 240 days.
Lordship and my lord, we are also working, my lord, not less than 240 days. The only difference was, my lord, Gopal Rai and others, they
They
filed
were impaneled following a separate selection process.
my same selection process. My lord, that advertisement 18 of 91.
This panel was prepared in March 1992. From the typed order page 5.
Page 5.
Whereas
Lordship.
the respondent number 5, 6, 7 was impaneled in a panel dated 4th December 1991.
But 4th December 1991 panel was prepared following the advertisement, my lord, which was published in 91. If your lordship, my lord, comes to the previous page, my lord, the advertisement was published in Telegraph on 5th of May 1991. And my lord, the recruitment process was held in 91 and the panel was published on 4th of December 1991. The panel, my lord, had 6 general category candidates, in which, my lord, those 3 candidates were impaneled and we were also impaneled.
That means respondent number 5, 6, and
7, they were also impaneled, and my lord, these 2 petitioners were also impaneled.
So your position in the panel is?
My lord, my position is 5 and 6.
5 and 6, and their position?
My lord, their position is 1, 2, and 3.
1, 2, and 3. 4 has not turned up.
4 has not turned up. My lordship, if I place the order, my lord, it will be clear. Now, my lord, I was at, my lord, second page. The said respondents appeared to be licensed dozer operators and have been working for not less than 240 days in the Damodar Valley Corporation and have been selected and impaneled in the panel dated 4 December 1991. They filed a writ petition which was registered as matter number such and such, which was allowed after a contest by a judgment and order dated 17 July 1995, making the rule absolute in terms of players A, B, and C. Aggrieved against the said orders, DVC authorities preferred appeal number 747 of 1995, wherein interim directions inter alia of status quo to be maintained with regard to continuity of the service of the respondent numbers 5 to 7, and a further direction was in effect, we have not stayed the operation of the judgment impugn. We leave it to the authorities of the appellant Damodar Valley Corporation to find out ways and means to absorb the respondents without prejudice to the rights and contentions of the appellant in the meantime. The respondents, Damodar Valley Corporation, have not filed their affidavit in opposition implemented. Respondent numbers 5 to 7 have also not filed their affidavit in opposition. From the records placed before the court by the respondent corporation, it is seen that post number 91 of 18, which is designated as dozer operator grade 3, the vacancies advertised were 10. And as per the advertisement, 6 has to be filled up from general category candidates, 3 from scheduled caste and 1 from scheduled tribe. The selection board interviewed and took practical test of 157 candidates and thereafter recommended for selection candidates in order of preference specified therein. A list of 88 persons is specified in the order of preference, and the note appended thereto states that only empanelment of the candidates were found suitable. The same is signed by a 5-member of the selection board on 2nd December 1991. There is an endorsement made at the end of the list by the Joint Director of Personnel R&T, which reads as under. As per CM's order dated such and such, in file number such and such, only one general candidate, BS number 65, 3 ex-servicemen number 65, 8 and 33 of the panel are to be afforded appointment. That is 7 vacancies, General 3, SC 3, ST 1 to be filled. The petitioners' names are found in the said panel in the serial as under. My lord, Lordship would get petitioner number 2 is, my lord, Munna Prasad Singh. My lord, his serial number is 5. And my lord, Gautam Maiti is 6. From the endorsement extracted supra, it is seen that in the general category candidate with RS number 55, serial number 1 of the panel was offered appointment. 6 posts are meant for general category. 8 ex-servicemen have been offered appointment who are at serial numbers 8, serial number 12, serial number 13 of the panel. In all, 7 appointments have been offered. 3 posts were kept as unfilled. 8 posts were filled up by scheduled caste candidates. The only question for consideration in the instant case is whether the petitioners are entitled to be offered employment on the post of their selection and impaneled pursuant to the notification, which as noted above was to fill up 10 vacancies for post number 91/18. It must straightaway be noted that the petitioners are from general category and only 6 posts can be filled up in that category. Petitioner number 2, Munna Prasad Singh, is impaneled at serial number 5 by the selection board, whereas others are not to be in the zone of consideration in view of the ranking assigned to them by the selection board. The petitioners obviously cannot claim appointment for the post reserved for scheduled caste and scheduled tribes. Learned counsel for the petitioner, however, relied upon Union of India versus such and such and contended that the existing vacancy should be filled up from the panel as approved by the selection board, and that unless the panel is exhausted, the respondents cannot make appointments to the said post of dozer operators, and any such action would be arbitrary. A similar contention has been selected by the Supreme Court in N. Mohanan versus State of Kerala. It would be useful to refer to the State of BR versus Secretarial Assistant Successful Examination 1896. The Supreme Court held that having been selected does not on account of being empaneled alone acquire any indefeasible right to appointment. Empanelment is at the best a condition for eligibility for the purposes of appointment, and by itself does not amount to selection or creating right to be appointed unless prevalent rules state to the contrary. In that case, selection was prepared on the basis of merit in the examined for without any qualification. All the persons who wrote the examination were ranked to the merit. They claimed the right to get appointment, contending that till the list was exhausted, no fresh list could be prepared and that they were entitled to appointment. The contention was known, and it was held that there is no provision in the relevant rules giving indefeasible right to the persons whose name appeared in the list to get appointed. In the light of the above contentions of the petitioners that until the panel is exhausted, the respondents could not make any appointments except from the said panel, any one of the existing vacancies has to be rejected. Pursuant to the advertisement for the post of 91/18, 10 posts alone will require to be filled up, of which 6 were from the general category, and the petitioners can only claim right, if at all, to any of the said 6 posts. In the instant case, no information have been furnished by the respondent as to how the said 6 posts general category have been filled up. Though from the endorsement it appears that 3 ex-servicemen have been offered appointment, they do not fall within the first 6 candidates in the panel prepared by the selection board. There is also no quota reserved for ex-servicemen for the said post, nor does the advertisement for notification specify any reservation for ex-servicemen. In these circumstances, the only appropriate order would be to direct the respondent corporation to strictly adhere in the filling of the said 6 posts of general category by offering appointment to candidates in the general category strictly in the order of ranking by the selection board. This writ petition is accordingly disposed of with a direction upon the respondent corporation to fill up the 6 posts of dozer operator grade 3 post 91/18 insofar as the general category candidates are concerned, strictly adhering to the ranking assigned by the selection board. And if any of the petitioners come within the eligibility criteria, they may be considered for appointment to one of the 6 posts in general category. The respondent shall complete the entire exercise within a period of 2 months from the date hereof, and also communicate their decision to the petitioners if any or all of them are found not entitled to be offered the post for the reasons thereof. My lord, this was the order. Now, my lord, pursuant to this order, my lord, we communicated this order. My lord, they did not give us any reply, my lord, pursuant to which, my lord, we were, my lord, compelled to file this writ petition. Now, my lord, if your lordship, my lord, takes up the record, lordship.
The period for filing contempt application goal.
My lord, 1 year. But only thing was, my lord, in the meantime, my lord, Gopal Rai's writ petition, my lord, went up to the Honorable Supreme Court. My lord, we were in the same selection process.
Who is Gopal Rai?
My lord, Gopal Rai, Trilochan Singh, and my lord, Shaheen Akhtar are the persons who are impaneled at serial numbers 1, 2, and 3.
1, 2, and 3.
Lordship. Now, my lord, if your lordship, my lord, takes up the supplementary affidavit, my lord, there was a direction passed by my lord Justice Shonji Banerjee, my lord, as his lordship then was, my lord, to annex all the documents, my lord, pursuant, my lord, in the case of my lord Gopal Rai and others. And my lord, the order dated 16th of January, my lord, specified that if the petitioners are found to be on the same footing with that of Gopal Rai, if your lordship, my lord, has a look at the order dated 16th of January.
Page?
My lord, that must be in your lordship's record. My lord, 6th of June 2016.
Yes.
My lord, if your lordship sees the order, leave is given to the petitioners to use a supplementary affidavit to disclose all orders pertaining to the writ petition filed by Gopal Rai. It is the petitioner's contention that their cases are governed by the decision in Gopal Rai and they are entitled to their salaries from December 1991 as has been paid to Gopal Rai. Let the petition appear a fortnight hence, the Damodar Valley Corporation will consider the assertion of the petitioners. It is more likely that if it is ultimately found that the petitioners are entitled to the same benefits as Gopal Rai DVC, may have to pay penal interest with a substantial portion thereof coming out of the pockets of the recalcitrant officers who resist the claim. So, my lord, pursuant to this, we took out a supplementary affidavit. Now, my lord, if your lordship, my lord, kindly comes to the annexures of the supplementary affidavit.
Yes.
Now, my lord, kindly comes to, my lord, the case of Gopal Rai. Now, my lord, if your lordship takes up annexure S1 at page 18.
Yes.
My lord, may I place this order? This is an order passed by my lord
Order.
Justice. Lordship, dictated order. My lord, at that time, my lord, may I place this order? Learned counsel for the petitioners has proceeded in absence of the learned advocates for the respondent since he could not be favored with another special date and time of hearing. Although the petitioners are 3 in number, they have been they being of the working class who operate dozers, it is not a fit case for rejection of the ground of misjoinder. The petitioners have been long retained by the respondents as casual workers. They are not mere manual workers. They are all appropriately licensed. They work and have been working dozers at all material times. Their casual nature of employment has been maintained by subterfuge of not allowing them to work continuously for the requisite number of days. Since their jobs are of a perennial nature, they have been connected with the organization in the same capacity for 8 years or so and are still so connected. They should be absorbed in the stream of regular employees. The claim of the petitioner goes little beyond than that of casual workers who have worked for a sufficient length of time at a government, at a job of permanent nature. They were all being interviewed sometimes in 1991, and all three of them being successful were impaneled as prospective regular employees, but the regular employment never came through. A supplementary affidavit was filed before Honorable Mr. J.K. Mathur, a retired judge of this court, almost the day before his lordship's retirement, wherein it has been alleged that the whole panel containing the names of 3 lead petitioners have been scrapped in January 1995. No reasons for discarding the panel are disclosed in the supplementary affidavit or in the opposition. The pay of the lead petitioners has been incomparably low when considered against the pay drawn by regular employees who perform the same jobs as the lead petitioners. The lead petitioners all accordingly ask for equalization of pay, at least from the date of the interview, in which all 3 of them are successful. According to the law now laid down for service matters, relief cannot be refused to the lead petitioners. There shall accordingly be rules absolute in terms of prayers B, C, and D. So, my lord, this order was challenged by, my lord, the Damodar Valley Corporation, my lord, before the Honorable Division Bench. Lordship would get this order, my lord, annexure S2 at page 20. My lord, before my lord Justice Mukul Gopal Mukherjee, my lord, as his lordship then was, and my lord Justice Siddheshwar Narayan. Now, my lord, may I please the dictated order? My lord, this is assailed by Damodar Valley Corporation in the matter of Gopal Rai, my lord, challenging the order of the learned single judge. Now, my lord, the division bench says, leave as prayed for in terms of prayer A is granted. Let there be an interim order of status quo as on today regarding the continuity of service of the lead petitioner, respondents as dozer operators. It was submitted by the learned advocate for the appellants that today they are in casual employment as dozer operators and they should be continued as such. The learned advocate for the respondents, on the other hand, contended that if any opportunity is available for their permanent absorption, they should be absorbed in accordance with law. Since we have not stated the operation of the judgment impugned, we leave it to the authorities of the appellant Damodar Valley Corporation to find out ways and means to absorb the respondents without prejudice to the rights and contentions of the appellants in the meantime. Now, my lord, thereafter, my lord, directions for preparation of paper books. Now, my lord, this appeal, my lord, is finally, my lord, taken up, my lord, by the Honorable Division Bench, annexure S3, page 22. Page 22, next page.
Yes.
Now, my lord,
There's a specially fixed matter.
That's specially fixed matter.
What is the ultimate order?
And the ultimate order is, my lord, if your lordship takes up
Page 47.
page 47. My lord, page 47 is the order. This is an appeal directed, my lord, the learned single judge has not passed any, my lord. What had happened was, my lord, they were in contempt, my lord, before the, my lord, learned single judge. So, my lord, the learned single judge passed an order in contempt. The order was assailed, my lord, before, my lord, the Honorable Division Bench. Now, the Honorable Division Bench, my lord, kindly takes up, my lord, the dictated order. The learned single judge has not passed any punishment in the contempt application. He has only given an opportunity to the contemners to abide by the order and report the matter back to the learned single judge. The present appeal has been filed against this order. The appeal is totally misconceived. My lord, the appeal was dismissed. My lord, this order passed by the Honorable Division Bench, my lord, was assailed, my lord, before the Honorable Supreme Court, page 49. Now, my lord, the Honorable Supreme Court remands the matter back, my lord, to the learned single judge of this Honorable Court by setting aside the order. Now, before, my lord,
An
the
appeal arising out of the contempt
contempt proceedings.
Proceedings. So the appeal order passed in the repetition remain unchallenged.
Unchallenged. Now, my lord, if your lordship kindly comes, my lord, now this contempt application is taken up for hearing by this Honorable Court. Lordship would get that order at page 54.
In contempt petition, the single judge did not pass any order of punishment.
Lordship. My lord, they thought that an order of
observed the same.
Appellate court observed the same. They went up in appeal.
Who went to the Supreme Court?
My lord, the Damodar Valley Corporation went up to the
Alleged contemner.
Alleged contemner went up to the Honorable Supreme Court. Lordship would get that at annexure S8, page 49.
49.
My lord, Munnu Prasad, my lord, is not Munna Prasad. My lord, Munnu Prasad is the authority of Damodar Valley Corporation. Now, my lord, when the matter is remanded back, my lord, to this Honorable Court, kindly comes to annexure S9, page 54.
Annexure S9, page 60.
Now, my lord, before the contempt proceedings before the learned single judge of this honorable court, my lord, this order is very relevant because this time, my lord, they undertake that they have given all the money to Gopal Rai, Shaheen Akhtar and Trilochan Singh. My lordship would get this order. This is an order dated 25th of August 2009.
Now, whether the order passed in the writ petition has been complied with or not?
Complied with.
Complied with and
all payments given. My lord, they have been granted the my lord, absorption in the permanent post of dozer operator grade 3. And my lord, salary since 4th of August 1991. Kindly comes to page 56.
yes.
My lord, lordship is getting on the basis of the aforementioned set of facts.
Yes.
On the basis of the aforementioned set of facts, Mr. Anjan Bhattacharya, learned counsel appearing for the petitioner states that so far as the prayers of the petitioners for absorption on the post of dozer operators are concerned, the same has been complied with. And the petitioners have been appointed as dozer operators. Mr. Bhattacharya, however, submits that so far as prayer C is concerned, the same related to a direction upon the respondents to make payment of the difference of wages paid to the petitioners and those paid to regular employees, similarly situated and performing similar duties, at least from the date of interview, that is 4th December 1991. According to Mr. Bhattacharya, this part of the order has not yet been complied with, and therefore the contemner opposite parties have violated the order of the learned single judge. My lord, notice was issued. Now, your lordship, my lord, comes to the final order. My lord, which is at page 59.
Yes.
My lord, that order is at, my lord, page 58.
Yes.
My lord, the learned, my lord, additional solicitor general appeared. It is stated by at the bar, Mr. Farooq M. Razak, learned additional solicitor general, that some steps have already been taken and rupees 1 lakh to each of the petitioners has already been paid, subject to the adjustment on final calculations. So, my lord, they paid it. He prays for some time, accordingly, let it be listed after 8 weeks. And my lord, kindly comes to the next order, page 59, annexure is 11. It is stated by Mr. Shubir Pal, assisting Mr. Farooq M. Razak, that the order of this court has been complied with. He has produced a communication dated 4th May 2011, issued by Director HRD and addressed to the Chief Engineer and Projected DVC Chandrapura under memo number such and such. The same is taken on record. In view of such submissions being made, contempt application no longer survives. The order of personal appearance, if any, is dispensed with, and the contempt application is dropped. So, my lord, they complied with the entirety of the order passed by the learned single judge. So, my lord, in the same selection process, my lord, these 3 candidates were at serial numbers 1, 2, and 3, 6 vacancies. My lord, they give it to 1, 2, and 3. My lord, after this long round of litigations, my lord, 5 and 6, these 2 petitioners, my lord, nothing has been given till date. And my lord, if your lordship, my lord, sees, my lord, the mode of compliance, my lord, they have been given their arrear salaries on and from 4th December 1991. That is the date of commencement of the selection process. They have been appointed permanently, my lord, to the post of dozer operator grade 3, which was the advertisement, my lord, the post which was advertised for. And my lord, their contention that the panel has been scrapped in the year 1996, my lord, was not at all taken into consideration by this honorable court. Lordship would get it from the order of my lord Justice Ajayanath Rai, my lord, as his lordship then was. So, my lord, during the tenure of the selection process, my lord, the entire panel, my lord, was challenged. My lord, the candidates, my lord, serial numbers 1, 2, and 3, my lord, they fought a very long battle, and my lord, in 2010, my lord, they have been given, my lord, entire benefits, appointment, dozer operator grade 3 against a permanent post, all benefits, my lord, on and from 4th of December 1991. So, my lord, we had participated in the self-same selection process. My lord, fall within.
Not open selection process, is it?
It was open, my lord, 158 candidates were.
Service. That means the selection process confined to the candidates who
who were working as
casuals.
casuals. My lord, within, my lord, the DVC. My lord, my contention is, my lord, 1, 2, and 3, we are similarly circumstanced to 1, 2, and 3 in all aspects. Whatever benefit has been given to them, my lord, should be given those benefits.
Yes, I've got. Yes, Mr. Talde.
Yes. My lord, the petitioners, my lord, has made out a case, my lord, for treating discriminatory, my lord, actions, my lord, against the petitioners. That was made out in paragraph 6 of the writ petitions at page 8, my lord. Paragraph starts from page 7.
Yes.
That since in the self-same corporation, Gopal Rai and others have been provided with all benefits according to law, but your petitioners have not been provided with benefits according to law, and the same is not at all sustainable in the eye of law, and the same is just like a whimsical, discriminatory, and malafide and arbitrary. Further, it should be taken into consideration that your petitioners appeared in the interview in the year 1991, and considering the said interview, panel was prepared in the same year, but due to the malafide and arbitrary act of the respondents did not provide the appointment to your petitioners till the date of passing of the order of the Honorable Court. And lastly, in compliance to the directions of the Honorable Court, respondents bound to give effect of the panel which was prepared in the year 1991. But when any one employee of the same self corporations has been provided with benefits from the date of interview, and other employees should not be ignored. Rather, other employees to be given same benefit considering the date of interview, and as such, same should be taken into consideration with retrospective effect. This is the, but in precise, my lord, this is the claim of the petitioners. Now, my lords, let it be examined, my lord, whether, my lord, the petitioners and this Gopal Rai and others, they are similarly situated or not, my lord. That has to be placed because that aspect has not brought to the notice of your lordship. I invite your lordship's attention first, my lord, the order and judgment passed by Gopal Chandra, in case of Gopal Chandra Rai, the filed a writ petition. What happened, my lord? The Gopal Chandra Rai, my lord, he joined the corporations as a casual worker, as a dozer, casual worker, and he discharged his duties till 8 years, my lord. Then thereafter in 1991, that the interview was held, Gopal Chandra Rai and others appeared as an insider candidate. That means they have already discharged their duties as a dozer for the last 8 years. And they are the petitioners before your lordship, my lord, they are the new candidate, fresh candidate. Pursuant to the interview, they approached before the authority, my lord. So there is a clear distinction, my lord. Then, my lord, that would be apparent, my lord, from your lordship's order, my lord, because what happened, they were
petitioners are not casual employee.
No, because what happened, my lord, they were given employment in the year 1997, pursuant to the order of the Honorable Court. Ultimately, they were given appointment in 1997 or after 1999. So I'm not quite sure, my lord, because there was a directions of this Honorable Court on a writ petitions filed by my learned friend. This is in the year 1998. So definitely appointment was given after 1990. The exact date, my lord, it is not apparent from after 98. So, my lord, the distinctions between Gopal Rai and the petitioners before your lordship is this, my lord. They already discharged their duties and responsibilities as a dozer for the last 8 years, and for which, my lord, so they were, my lord, called on for interview as a insider candidate, and they are all fresh candidate, and their empanelment was made, my lord. Though, my lord, it is well settled law, as your lordship is well aware, my lord, that the mere empanelment, my lord, in the panel, my lord, mere empanelment does not create any right, my lord, for the appointment, my lord, unless the actual appointment is to be given, my lord. So actual appointment is given sometimes after 1998. So from 1991 to 1998, they didn't discharge any duties as a dozer. And what happened in case of Gopal Rai? There was an administrative delay, my lord, in giving appointment. They moved a writ petitions before this honorable court, my lord. And in that writ petitions, they clearly prayed in that writ petitions, my lord, their prayer, my lord. In the writ petition, though, my lord, I have got it, my lord, I have put it in my precise list of date, my lord, but
They claim absorption.
yes,
You will
yes.
say
A
they,
writ of in the nature of what was the prayer of Gopal Rai? A writ of in the nature of mandamus to issue commanding the respondents concerned for or their servants and agents for making payment the difference in wages paid to the petitioner and those paid to the regular employees similarly situated and performing similar duties at least from the date of interview, that is 4/12/1991, and to act in accordance with law. So this prayer, my lord, was made absolute because the writ petitions was disposed of, my lords, in terms of the rules, my lord. So these rules were made absolute by this honorable court, my lord. So their case is completely different. So not only, my lord, there was a delay in giving appointment. Against that inaction, they came before the writ court. Not that, my lord. That apart, my lord, since they were discharging their duties as a casual worker for the last 8 years, so therefore they claimed their benefit at least on the date of interview, that is on 1991. And that prayer was allowed, rule was made absolute. But in their case, my lord, this honorable court, my lord, has not passed any order directing to give effect from 1991. So therefore, what happened? Because what was the order passed on their writ petitions? I invite your lordship's attention, my lord, at page page 17, 18, 17. Then operative part of the order. I will not-
party part, yes.
Yes, my lord. At 25A, my lord. In the circumstances, the only appropriate order would be to direct the respondent corporation to strictly adhere in the filling of the said 6 posts of general category by offering appointment to candidates in the general category strictly in the order of ranking signed by the selection board. This writ petitions is accordingly disposed of with a direction upon the respondent corporation to fill up the 6 posts of dozer operator grade 2 as general category candidates are concerned, strictly adhering to the ranking assigned by the selection board, and if any of the petitioners came within the eligibility criteria, they may be considered for appointment to one of the 6 posts in the general category. The respondent shall complete the said exercise within a period of 2 months from the date thereof, and also communicate their decisions to the petitioners if any or all of them are found not entitled to be offered to the post of reason therefore. So therefore, my lord, court was directed to consider the case of the petitioners for giving appointment to that post, my lord. Ultimately, my lord, authority, my lord, considered, my lord, but at the same time, my lords, that the Munda Prasad, my lord, that the petitioners before your lordship also furnished an undertaking before the authorities, my lord, that he will not claim any benefit, my lord, of grade B. This is a true copy, my lord. And this is
During pendency of this?
Yes, my lord. Yeah, because, my lord, yes, my lord.
Pendency of this proceedings?
No, my lord. During this period, my lord, because the order directing to consider the case of the petitioners by the authorities, my lord. Then in between, my lord, then this undertaking was made, my lord. Then ultimately,
Suddenly he approached you, he attended your office and gave this undertaking.
No, no,
So
my lord. That,
what was the occasion to get such undertaking from a candidate?
no, because that is why, my lord, that the affidavit was required, my lord, to file all these facts of the case, my lord. Because
they participated in a selection.
No, that is why there was a distinction, because they extended the benefit since 1991. Because they discharged their duties.
Forget about the year,
Yes.
whether the
So they are claiming the same benefit.
petitioner are similarly situated with Gopal Rai and others.
Yes, no, not similarly situated.
Forget about, they
Yes,
are not, for the sake of argument, they are not similarly situated.
Yes.
But the order passed in the writ petition have got the binding effect, it is binding inter partes.
No, yes.
It's binding upon you.
Yes, my lord, directed to consider the case of the petitioners, my lord. There was no direct direction.
Whatever direction is direction.
Yes.
Has been given.
Yes, my lord.
Given, it is
Yes.
binding as on date.
Yes.
It is binding upon you.
Yes, my lord. Yes,
binding
yes.
inter partes.
Yes, my lord.
So you comply with the direction.
That was complied with, my lord.
The order.
Appointment was
passed
given,
in
my lord.
CO number 15440.
This is Munda Prasad before your lordship. He was giving appointment after 1998.
My lord, 98 we claim it, my lord, from 4th of December 91. Gopal Rai has been
That is
given
why my
from 4th of
submission.
December 91. We got the appointment in 1998. Our
You
contention.
have been appointed.
Yes,
Yes, my
appointed
lord.
dozer operator grade 3. But my lord, we say that we should be given Gopal Rai and I, my lord, participated in the same selection process. My lord, the panel was published on 4th of December 1991. Gopal Rai has been given appointment, my lord, effect of appointment from 4th of December 1991. All area wages, my lord, with effect from 4th of December 1991. So, my lord, we claim the same benefit as Gopal Rai. Because, my lord, it is not the case, my lord. My learned friend said that we have been appointed in 1998. That is our permanent appointment. But, my lord, we have been working in Damodar Valley Corporation, my lord, for the last 8 years, like that of Gopal Rai. My lord, we, my lord, participated in the same selection process as that of Gopal Rai. My lord, 6, my lord, lordship has seen, my lord, 6 vacancies. We were within those 6, 1, 2, and 3, given all effects and benefits. My lord, on and from.
Got the appointment
I've got
letter
the-
of Gopal Rai.
But I've stated that in my writ petition as well.
Darao.
But appointment
Any
letter of Gopal, that is annexed with the writ petition.
Yes.
Apno, dekhte dao.
Take me to this, to her, his.
My lord, kindly takes up the supplementary affidavit.
Supplementary affidavit.
My lord, page annexure is 4, page 23.
Page 23.
Lordship.
Yes.
My lord, this is the appointment letter given to Gopal Rai. In compliance with the order of the Honorable High Court, Calcutta, dated 17 July 1995, your appointment in DVC, you are hereby offered employment in Group C of Junior Technician Grade 3 Dozer Operator as per the terms of the appointment given below. Lordship has got one at annexure S4, page 23.
Yes, got it.
My lord, this is the appointment letter of Gopal Rai. My lord, page 27 is the appointment letter of Shaheen Akhtar. And page 31 is that of Trilochan Singh. And I have been appointed in 1999.
His stand is totally different. He is ultimately claiming that he has not given employment to Gopal Rai since he was selected in the selection process and was empaneled. Since he was a casual employee and were going on serving continuously, and he claimed equal difference of pay on the basis of principle of equal work, equal pay with the regular employee, and accordingly his service was absorbed and regular pay at par with the regular employee was given, not as a empaneled candidate. In the order dated 17th July 1995, it was they submitted that panel has been scrapped. Yes. The whole panel continue the name of 3 petitioner has been scrapped in January 1995.
And next line, no reasons for discarding the panel are disclosed in the supplementary affidavit or in the opposition. But my contention is, it was, my lord, the selection process was on the basis of an advertisement, in which, my lord, they interviewed 158 candidates.
Now,
But it
this
was a-
order was passed in a writ petition. Justice M.H.S. Ansari, his lordship then was, when?
And it was passed on
2/4/1998.
2/4/1998.
And they have given salary from which period?
My lord, from my date of joining, that is 1998. If they give it to Gopal Rai, my lord, if it is an if it is a selection process based on an advertisement, my lord, in which, my lord, everyone has to be treated equally, because, my lord, we are all participating in a selection process. My lord, the race, my lord,
Now your only way out, if you can prove that the Gopal Rai was given appointment as impaneled candidate.
my lord, that is the case.
Not his appointment, or he has been absorbed in the post as a casual employee.
Lord, I invite your
But
lordship's
he has been-
attention, Lord, to the order passed on a writ petitions filed by Gopal Chandra Rai at page 18 of the supplementary affidavit.
It is a dictator.
Yes, my lord, that the writ petitioners have been long retained by the respondents as casual workers. They are not mere manual workers. They are all appropriately licensed. They work and have been working dosar at all material times. Their casual nature of employment has been maintained by a subterfuge of not allowing them to work continuously for the requisite number of days, since their jobs are not a perennial nature. And they have been connected with the organizations in the same capacity for 8 years or so. So this is the background.
Kindly comes
And they, my lord, they simply joined in 1999. They have never performed any work.
Kindly-
And how they are entitled to get this benefit?
No, another matter. You are claiming that you are giving Gopal Rai and others appointment in terms of the order dated 17 July 1995.
Yes.
So why are you giving appointment since the date of commencement of the selection process?
Because
4th December 1991.
Yes, my lord, because that was the prayer in the writ petitions, my lord. That the
Prayer you are claiming, I have not seen the prayer as yet.
Yes.
I shall seek your assistance where the prayer is.
Yes, my lord. In my list
prayer
of
has
date,
been
I set out the
cannot
prayer,
be-
my lord.
But this question is not clear. You are claiming that
that's right.
you have absorbed the service, you have absorbed the Gopal Rai and 3 others since they are in
Yes, my lord, in my writ petitions, there are my lord, twofold of prayer, my lord. One, my lord, for there was a delaying in giving appointment, so therefore to give appointment. And the second, my lord, since the petitioners was performing the duties, my lord, at least that benefit should be extended with effect from 4th December 1991. That is the date of interview. That my lord, I read out, my lord, the prayer, my lord, made in that writ petition. A writ of in the nature of mandamus to issue commanding the respondents concerned for their service. Page, my lord, this has not been
This is not
mentioned,
a
my
part
lord,
of
in
the
it. That is why, my
records.
lord, my lord,
My lord, your lordship's
insisted
query,
lordship's
my lord, is
to have an
perhaps at
affidavit.
page 19. Now, my lord, my learned friend says that they had only considered their case since they are working for 8
No, my lord,
years.
the governing law, my lord, on these issues is this, my lord. Unless a party,
Your
my lord,
lordship,
who
my
is
lord,
not perform
reads
the
this
duties, they are
paragraph
not
as a whole.
entitled to any
Claim of the writ
benefit, any
petitioner
salary.
goes a little beyond than that of casual workers who have worked for a sufficient length of time at a job of permanent nature. They were all interviewed sometime in 1991, and all 3 of them being successful were impaneled as prospective regular employees.
Yes,
So, my lord,
yes.
Lordship
that was
square.
Considered,
Sir,
they were
এক
given
second, একটা কথা
appointment.
একটু বলে নিন, তারপর বলছি। Lordship's query was, my lord, whether I can show that Gopal Rai and others were impaneled. They were impaneled.
They
And my
were
lord, the
empaneled
second
even
part of
as
the
a
order,
fresh candidate.
my lord, the second
They
part of
never
the order,
discharged their duties. So unless they have performed their duties, my lord, how they can claim this benefit?
my lord,
Whereas Gopal Rai did it and he prayed for in the writ petition. And that prayer was made absolute.
it was a selection process after all.
That was made absolute. So pursuant to the order of this honorable court, Gopal Rai extended this benefit because initially this was not. Ultimately, contempt was moved, my lord. Then matter went up before the Supreme Court. Supreme Court further directed to consider the case by the trial court. Then thereafter, my lord, this benefit was extended to Gopal Rai. So these circumstances are not involved in their case. Because they are a fresh candidate. And he discharged 8 years duties. So therefore he claimed that at least such benefit should be extended on the date of interview. And that was given. But in their case, in their order, there was no such order and there was no such prayer. They can't because they never performed any duties. How they can claim the salary? How they can claim the benefit with that of Gopal Rai? That's the distinguishing feature.
So you have not rendered any service for that period.
Yes,
my lord, I was in service, my lord, at the time, my lord, from which Gopal Rai was there. My lord, it is a wrong submission. It is absolutely a wrong submission that Gopal Rai worked there for the last 8 years. I was along with Gopal Rai, my lord, prior to even commencement of this election process. I am not a fresh candidate. Now, my lord, if your lordship was looking at that page 19,
Any documents is there to show the same.
but that I have to bring it on record. My lord, let my learned friend file an affidavit disclosing this stand. I will reply to.
No, that cannot be, my lord, because he has used affidavit.
Where is
The
the
matter
affidavit? You have not
Can,
filed
but-
opposition. But now your lordship, my lord,
Because I
kindly
was also
comes
not
to,
allowed.
my lord, kindly comes to that same page 19, paragraph 3.
Then, my lord, I will also invite your lordship's attentions in the writ petitions, my lord. Nowhere it was stated, my lord.
The pay of the
how,
writ
my lord, they will be
petitioners has
treated
been
alike, my lord.
incomparably low when considered
they will be
against the
treated
pay
alike,
drawn
my
by
lord.
the
There
regular
was no
employees
averment.
who perform the same jobs as the writ
Claiming for-
petitioners. The writ petitioners accordingly ask for equalization of pay at least from the date of interview in which all 3 of them were successful. So, my lord, that was the prayer that I should be, my lord, since I have participated in this election process in 91. My lord, I have not been appointed till date. So, my lord, whenever you consider my claim, consider it with the, my lord, pay which is given, my lord, to the employees performing similar work. And my lord, we are, my lord, working in DVC, my lord, the condition was 240 days of employment. My lord, I had performed 240 days of employment there, my lord, therefore, I was found eligible to participate in this election process.
So where is the advertisement
My
of
lord,
the,
advertisement,
or the order?
but I shall,
inviting
my lord, let my,
the candidature for the post? Where?
but I shall bring that advertisement, my lord, keeps it next week, I shall bring that advertisement. Old matter, it is a transferred brief to me. So, my lord, I don't have all the documents in hand. Keeps is a parted matter any day. I shall bring that advertisement.
Both the
No
fighters
record
are without any weapon in their hand.
But it's
Huh?
a matter, my lord.
No
My lord,
record
when
public.
my lord, this matter
No
took
case was
origin when
made
I
out
was
in the
in
writ
school.
petition.
Perhaps, my lord, I have got this brief. So, my lord, I have the paper book of Gopal Rai that must contain the advertisement. I shall bring it. Keeps it tomorrow or Friday, I can bring it.
Have the learned advocate.
Then,
appealing
my
for
lord,
the
then, my
respect-
lord, it is better, my lord. Both the party, my lord, given, my lord, opportunity, my lord, to file me the respective documents, my lord, and, my lord, their affidavits, my lord. Otherwise, my lord, it would be very difficult, my lord.
have the learned advocate appealing for the respective parties at length. ঠিক আছে, আচ্ছা। Here in this petition, the petitioner has come up with a prayer for issue of a writ of mandamus directing the respondent to pay salary and all the benefits, salary and all the benefits to the petitioners from the date of commencement of the selection process, as has been commencement process, আচ্ছা
গোপাল রায় জয়েন করেছে
আচ্ছা stop. The petitioner has claimed that such benefits have been extended to the private respondent number 5, 6, and 7. Stop. Inviting my attention to the order passed in CO number 15440 of 1995 and the order passed in matter number, this is 3758 of 1993. The petitioners claim that such benefits has been extended to the respondent number 567 who are identically circumstanced with the petitioner. Stop. Mr. Tarabdar vehemently opposed such contention, claiming that the petitioner and the private respondent number 5 are not on the same footing. He asserts that the respondent number 5 and 6 and 7 were a casual employee of the casual employee of DBC, and their job they have been in the post.
Those are operated.
In compliance with the
those are
order
operated.
dated
Yes. 17 July 1995.
17 July 1995. ঠিক আছে? আচ্ছা। So the writ petitioner cannot claim parity. আচ্ছা। Parity with the private respondent number 5, 6, and 7. Acha, in reply, Mr. Sajasal, and advocate appearing for the petitioner, assert that petitioner was also casual employee, and so the questions come whether the petitioners were casual employee or not, and whether the respondent number 5, 6, and 7 were given appointment as empaneled candidates. ঠিক আছে? Empaneled candidates in the panel which was prepared following a selection process initiated in 1991.
1991.
ঠিক আছে? আচ্ছা। The parties, both the learned advocates press for leave from this court to bring some documents in support of their respective claims. ঠিক আছে? আচ্ছা। By filing affidavits. In view thereof, the leave is granted to the respondent to file affidavit in opposition. ঠিক আছে? আচ্ছা। To clarify their stand, including their stand on the issue raised today in course of hearing. Today in course of hearing. Stop. Petitioner is also at liberty to file affidavit in reply, dealing with the averments and the documents which would be made and annexed in the affidavit in opposition.
One prayer, could it be parted before your lordship?
Let such affidavit in reply be filed within
below 4 weeks, my lord.
4 weeks.
4 weeks.
3 weeks. 3 weeks.
So within 3 weeks, reply
1 week.
to
1 week.
Be filed within 1 week. Thereafter, list the matter for further consideration. 4 weeks since.
But could it be parted by your lordships? Your lordships has heard it, my lord. Let it be parted before your lordships.
If every matter I heard, I am making endeavor to dispose of.
The only thing is, my lord, if it goes to a different.
You raised the point.
Yes.
And he also raised the point. You didn't bring any document to show the same. Whether he is casual employee or not, whether he was appointed as an panel candidate or not.
But that is the crux of the matter.
Okay, it will remain in my list. Don't worry.
I'm grateful to your lordship.
Next.
I declare for the petitioner.
20.
I declare for the
Yes.
petitioner. Your Lordship, on the last occasion, your Lordship has given.
Mr. Arun Banerjee, I am praying adjournment for the day.
No, my lord, may I submit one thing, my lord? Perhaps adjournment is not required, my lord. My lord, the writ petition has already become infructuous.
Why?
My lord, they prayed for release of their compensation amount. Their allegation is this, my lord, the advertisement was not made and money was not released. My lord, I have brought the report, my lord, at due advertisement were there and money roll has been made. They have not,
Acquisition matter.
my lord, they have not collected the money, my lord. I have the instruction, my lord, for if
Your
they,
Lordship, we are challenging.
Award was declared.
yes.
Your Lordship, we are challenging the quantum amount they are submitting today.
File application under section 18.
Yes, not before this
But Your
court.
Lordship, the process, the award has been passed, is to be looked out. If your Lordship kindly comes to the FE opposition para 9,
If you dispute the
the process of compensation.
quantum of compensation, there is another forum, another procedure. You have to avail of section 18.
My lord.
Act 1.
Act
Section 18.
Your Lordship. Then the application to the
Steps, their prayer is, my lord, kindly see page 17.
Oh,
My lord.
when the acquisition proceedings was initiated.
Now kindly come to
This writ of 2014.
14.
When the acquisition proceedings was initiated?
2009.
2009.
2009.
My lord. After
So
publication,
section 3, section 4, 2009.
publication
When
in the
section
Gazette.
6? Section 6 when? Our award was ultimately declared.
Yes. After due publication.
Notice under
section,
12 2 under section 12 was given to you.
Yes.
Your Lordship.
Yes. I have that copy. Notification was made in the Calcutta Gazette. Thereafter, it has been published in the Ganashakti. Thereafter, it was published again in the Kolkata Gazette. Lord, I have that copy, Lord.
Can I get a copy?
LA case number
File exception.
83 of, Lord, what is use of filing exception? Because it has become infructuous. If they challenge the quantum, Lord, it will before the district judge, Lord. Your Lordship knows it very well, Lord. And
You prepared this petition seeking a direction to release
yes,
the land.
yes.
That cannot be. As and when the declaration under section 6 is published, the land is vested to the state. You know very well.
Your Lordship. But this
Now that direction cannot be given.
But if your Lordship can a copy of the report can be
Oh.
handed over.
Copy can be given, my lord, but petition can also be disposed of. My lord. Behind, Lord.
So keeping this copy with the record, I am disposing of assets.
This
But
exception
in
to
the
be.
meantime, yes.
And copy this, my lord. Copy, yes.
When the award was declared,
LA case of 2008 and 9, my lord. Thereafter, they were declared thereon, my lord. Award was award number 172. Next page, my lord, page 2, my lord. Can you see? Award was declared
it's
on.
declared in section 6. Award.
Mhm. 16/7/2014, I told, my lord. But kindly see annexure 3, my lord. Kindly come to annexure 3.
So with the petition and approach section 18, huh?
29829 was the amount.
My lord, Mr. Samantal, learned advocate appearing for the state submits that here, after completion of the acquisition proceedings, because award has been declared. Stop. Declared in? Award has been declared, stop. Oh, okay. The petitioner submits that he's aggrieved with the quantum of aggrieved, and he has aggrieved and are dissatisfied with the quantification of the compensation, with the quantum of compensation as assessed by the competent authority. So, yes.
My lord, I am for the petitioner, my lord. I have been told that the state is filing a report.
But I need to take instruction on the basis of the report as well as the.
Award has been passed.
Now, my lord, in that context, my lord, may I submit, my lord? The award that has been passed, my lord, we get to know from today by this report. Now, I need to take instruction from my client. Now, my lord, I do not have instruction as of date. My lord, if your lordship kindly keeps it out tomorrow or day after, my lord, I can come back with the information. Now, my lord, this is our, but the family members are residing there for the last 50 years. But the WBDIC has filed their report yesterday. I have got the affidavit in opposition. I need to file my reply to that, my lord. But I need to
No, perhaps
give
Milord,
me an opportunity of hearing,
the
my lord.
present context, Milord, it perhaps not maintainable. Kindly see the prayer, Milord. Kindly see the prayer,
But
Milord.
whatever it is, my lord, keeps it for final hearing. In the meantime, my lord, may I
What is
complete
the
my
requirement of
pleadings?
final
my lord?
hearing? I don't know,
May I
Milord.
complete my pleadings?
But the writ is not
opposition has been
maintainable. It
served
has
to
become
us yesterday, my
infructuous.
lord. I'm being told that the state is filing a report today. My lord, let me take an instruction on that basis, my lord.
It has become infructuous as of now, my lord.
Declaration and notification under section 6 was published in 2009.
But nothing is with us. That is why we raised this objection.
And there is no provision. Legislature has not made any provision that all the notification will be personally communicated to
be that as
all
it may, my lord.
No.
Yeah,
My lord, be that as it
land
may.
user.
My lord,
No.
be that as it may, my lord, may I humbly submit? May I take an instruction from my client? My lord, keeps it
Okay,
tomorrow or
come
day
tomorrow.
after.
Come tomorrow.
My lord, let a copy be given to us. I'll take instruction.
Well, instead of tomorrow, Friday, my lord.
Huh?
Instead of tomorrow, my lord, kindly fix on Friday.
Friday.
My lord. Thursday, there will be holiday.
My lord, I'm appearing for the respondent number 8, my lord.
But they have
I
served us a copy.
You are
Respondent number 8 in the matter, my lord.
respondent number 8.
Bengal Aerotropolis Projects Limited. So, my lord.
Requiring body.
Requiring body.
Yes, yes.
Land has been handed over to you.
Yes, my
Yes,
lord.
my lord.
It is you will say land has been handed over.
Yes, it has been handed over, my lord. We have
But
served.
still he is in possession.
Yes.
Yes, we have served the affidavit in
I
opposition.
am in possession.
Yes, may I just hand up a copy of the opposition?
But they have served us a copy of the opposition. My lord, let us.
Don't do this. There was a stage. 5A, you could have raised objection under section 5A.
But these are illiterate persons of villagers.
Now,
My lord, whatever it is, my lord, may I get an opportunity to file an opposition reply to their opposition, my lord?
no, reply, you take instruction and come. Yes.
My
Come
lord,
on,
the
Friday.
report be handed over to us, my lord.
Yes, yes.
A copy of the report.
But I will.
Uh,
But kindly record it on. Record that, bro. Kindly record that, my lord.
But keeps it on Friday, my lord, we'll come.
Yes.
Yeah, had the planet advocate appearing for the parties. In course of hearing, Mr. Samanto submitted some documents and claimed that the award has already been
Published.
Because, and in view according to Mr. Samanto, in view of such facts, the writ petition has become infructuous.
My lord.
Stop. Acha. Mr. Sasansa, learned advocate appearing for the petitioner, placed for a short accommodation to avail necessary instruction. Stop. Acha, in view thereof, list the matter. What is this?
My lord, the affidavit in opposition on behalf of respondent 8.
The
Is
copy
there
may
any
be handed over to us.
But there are certain things, my lord, we need to address, my lord, by way of reply, my lord.
There was a direction to file affidavit.
Yes,
Yes,
my
my
lord.
lord. Yes. But though they send me a mail in February.
Now you are also creating obstruction to the development work.
Yes, my lord, there was one obstruction, my lord, in March.
But we are residing there with my family for the last 50 years. It's an ancestral property.
That will not vitiate the entire acquisition proceeding. Learned counsel, you know very well. Mayor staying on the land or residing on the land will not vitiate the entire proceeding.
The issue is that no opportunity of hearing was granted to us. Since an opposition has been filed, my lord, let me file my reply to that.
আচ্ছা উপরে লিখে দিন affidavit opposition filed on behalf of the respondent number which is kept is taken on record. ঠিক আছে? Okay. Okay, you come on the next day taking instruction. Okay.
But since Eid is there, well, they will be celebrating.
Whether there is a requirement of any reply or response of the affidavit opposition.
Therefore, Malad, I'm saying, Malad, they will be celebrating their Eid tomorrow or day after. Malad, I may not have the proper instruction if they want to file the reply. Malad, in that event,
reply not necessary.
My lord, Malad, I shall take instruction.
Okay.
If that be so, Malad.
It is the burden upon the court to dispose of.
Yes, Malad, definitely.
So it is the duty of the court to give judicial answer to the query raised in the writ petition.
Absolutely, Malad.
So whether reply is required or not, it is the court to decide.
Yes, Malad. Malad, as a petitioner, Malad. As a petitioner, I need to assist your lordship in a proper way.
Another 4 years will go.
No.
Even in the
No, the issue is, Malad.
There is any valid ground of challenging the acquisition because
But the issue is
they have not been given any notice. Now, no notice, individual notice is given in an acquisition. Only not notification in the gazettes.
That has been done.
Friend produces that.
I have produced.
He has got no other ground of.
But even if I have a bad case, Malad, I need to address your lordship in a proper way, Malad. Since an opposition has been filed, I need to file my reply, Malad. That is my humble prayer.
No, whether the REIT is at present is not maintained has become
Be that as it may, my lord. Since they have filed an opposition, my lord, I need to address your lordship by way of a reply, my lord. And a report has been submitted, my lord. I'll definitely take instruction by Friday, my lord. I'll definitely, my lord.
This is not a report. This is an
come on Friday. If
Yes, yes.
court requires, court thinks that affidavit in reply is required, then such liberty will be given.
That observation may be taken, my lord. My lord, kindly.
No such observation.
Grateful, my lord.
Even necessary instruction, leave this matter for further consideration on 12th. ঠিক আছে? On 12th, after completion of division bench,
the lordship will be sitting here.
Okay.
Grateful, my lord. My lord, kindly direct the respondent number 7 to hand over a copy of the opposition. 8, my lord.
Hey, hand over.
Great.
For the petitioner lordship, I'm praying for 2 weeks adjournment, same as item number.
Achha, same as item number 11. Yes. 22.
My lord, I am praying for adjourn 1 week, my lord.
Achha, not this week. 23.
For respondent number
23 minute, I am only praying for 1 week accommodation.
Not this week, yes.
22, my lord. I am appearing for the respondent, my lord.
22.
Yes, my lord.
22 accommodation for this week has been sought for on behalf of petitioner. So not this week.
My lord, I'm paying for 2 weeks, my lord. Today I
Adjourn for 2 weeks.
highly obliged, my lord.
2 weeks. 2 weeks. Yes.
24.
24.
But I am for the petitioner.
Who is for your other side?
But one Mr. Sharma and Mr. Talukdar, he appeared on the last
Luconet
occasion.
Health Limited.
Yes. Luconet Health is a government company, my lord.
Their presence is required.
Their presence is required, my lord, particularly the company, my lord, they are the answering respondent. They initiated a disciplinary proceeding against me, terminated me, and society is not, my lord, not the answering respondent. Last occasion they appeared. I do not know what happened.
So not today, if you can bring them tomorrow.
Very.
Okay.
My lord, kindly make it not this week. I shall give a notice.
Okay, not this week. Didi. 26.
We are the respondent. We are the learned advocates on appearing on behalf of the petitioner informed us that they will take adjournment.
For this day or this week?
Not this week.
Not this week. Okay, not this week.
In a fortnight. For the fortnight. It would be a pleasure for your lordship to adjourn this matter for fortnight.
Oh, adjourn for 2 weeks. 2 weeks.
Yes, lordship.
Next matter is also same?
Same.
2 weeks.
28. 28, my lord, I am for the petition. I'm praying not this week, my lord.
Not this week.
Grateful, my lord.
I am for the petitioner.
You are in it matter also?
Sometimes.
Sometimes. Who is for your other side?
Other side, Mr. Bihani, Noyan Bihani. One of
Bihani came here today.
very old matter.
You are seeking direction upon the respondent number 4 to execute a deed of lease in your favor.
Where from your lordship is reading?
Cancelling a letter dated as such and such issued by the executive officer Digha Sankarpur Development Authority.
Where your lordship is reading from?
Can a writ court give such direction? A owner has the every authority to deal with his property according to his choice.
My lord.
Whether he will give lease or mortgage or sale, it is his discretion to decide.
Here in this case, the discretion was exercised by both the parties on consent, and premium was paid in full, and they agreed to execute.
Digha Development, which is a state. That means
there is no dispute
the
at all.
contention is the state entering into a contract is not performing his part.
In spite of having received the full considered non-matter premium.
You are appearing for
Lordship, in this matter, Mr. Bihani is appearing for DSDA. Lordship, he is on legs, Lordship. I am prayer for only not today, Lordship.
In that event, only you also make it not next week, Monday.
Next week, what will happen like that?
Tomorrow, your lordship will be sitting, I think, tomorrow.
To come tomorrow?
Good way. Kindly let us take a chance tomorrow.
Tomorrow.
Grateful, lordship.
I am for the petitioner. In 30 minutes, I am for the petitioner. This is old matter. And the petitioner was dismissed from service. And, disciplinary proceedings matter. Yes, my lord. You are dismissed. Yes, paper statutory appeal. Yes, that was decided against you. Then you have challenged both the. Yes, my lord. But on the last occasions, other side appeared. And who is your other side? Other side. Saha. he has Kalidas Saha, he appeared and Madam,
But no direction for affidavit in opposition has been given?
no, Madam, no affidavit has been filed, but Madam, Mr. Justice Kapoor once heard this matter, and his lordship was pleased to direct the parties to file written notes of argument. I served a copy of the written notes of argument upon their respondents, but they did not supply me a copy. And the matter was taken up for hearing before my lord, and I submitted that I shall add something on this, the written notes of argument. And now my lord, I shall.
In February also,
Yes, my lord.
Kalidas Saha appeared on behalf of Union of India.
Yes, ma'am.
In January, Indojit Dasgupta and
Yes,
Pushpita
yes, ma'am.
Bhaumik appeared for the.
Yes, madam. Previously, Mr. Indojit Dasgupta appeared. Now, Mr. Kalidas Saha is appearing. On the last occasion, he appeared.
So we give notice to,
Then, madam, this is a dismissal case from 2010. Lordship kindly allow me, I shall ring him.
on two occasions, it was dismissed for default.
But matter was restored.
It was filed in 2010, 14 years ago.
Yes, madam.
Then you are too young.
Yes, he was
Huh?
here. Yeah.
That day.
Yes.
You filed.
So also
14 years ago.
Pardon?
14 years ago you filed.
14 years ago. And
dismissed on two occasions.
I'm 2 occasions and matter restored on 2 occasions and the matter taken up for on several occasions.
In such a way you pursued the matter, it was dismissed on 2 occasions and for 14 years it is pending before this honorable court.
Yes.
No application for early hearing or anything like that.
So also kindly hear this matter tomorrow, my lord.
Tomorrow?
I shall know inform him.
So all the things.
I'm for the, sorry.
Oh, he has come, my lord.
You are appearing in this matter?
My lord.
You are ready?
Well, this is a transfer. Well, there's a file. I have already filed my pairwise comment before your lordship.
No. Paravers comments is no, my lord.
Not there.
Is with the record. No.
So kindly allow me some days because I have
Any paravers
instructed that pairwise comment already filed
Paravise comments.
by former baby David.
Hmm?
By former baby David.
In
Baby David
form of
opposition.
affidavit. You have prepared it.
My lord.
Have
Already-
you served the copy?
Nothing has been.
I have instructed that was already served and filed. This is the transfer bill.
No. Nothing has been served on me.
In the month of January 2010, direction was given upon both of you to file written notes of argument.
Yes.
And exchange the copies thereof.
Yes. Madam, I served a copy upon them, but they did not serve their copy on me.
My lord,
You file written notes of arguments. Let us try whether on the basis of such written notes, the matter can be disposed of or not.
my lord, inquiry has been completed. Inquiry has been completed. Departmental inquiry and charge sheet already filed, my lord.
Yes.
My lord, kindly see the page number 26 of charge sheet, my lord.
The charge sheet file, discipline proceedings ended, with the issue of order of removal, statutory appeal filed, appeal dismissed, challenge.
Everything complete.
So
Now,
kindly, my lord,
what is the allegation?
Allegation is unauthorized absence.
Unauthorized
Unauthorized absence.
All time, my lord, kindly
my
see
lord,
the page number 26.
And my lord,
But he was absent.
I shall cite Supreme Court cases where the Supreme Court held mere unauthorized absence is not a misconduct unless there is a clear finding that the absence is willful. There no case for misconduct can be made out. And my lord, I shall also
another case before my lord, if my lord permits me, there is similar case of misconduct. The petitioner in that case admitted his guilt, but he cited reasons that for circumstances beyond his control, he remained absent.
Well, you are in custody.
Pardon?
No. You are in custody.
No. No. And in that case, the authorities imposed the punishment of removal from service. In that case, Supreme Court ultimately held the punishment of dismissal in the facts of that case is disproportionate and set aside that order of removal and directed for reinstatement. I shall cite those cases if my lord permits me. And if my lord permits this. And before this, my lord, one point, he was not there, but Mr.
Dasgupta raised.
Huh?
Mr. Dasgupta raised.
Yes, Dasgupta raised one point on one preliminary point before Justice Kapoor regarding the territorial jurisdiction of this Honorable High Court. And Mr. Justice asked me to elaborate this point in my written argument. As I have got the opportunity before my lord, I can argue. If my lord permits me, then I can note down this in my written notes of argument. But the inquiry was held in Patna. Dismissal order passed from Patna. And statutory appeal dismissed in Patna. And that order was both the orders were communicated to me in my native village in South 24 Parganas. So I received the order of removal and also the order dismissing my appeal at my native village in South 24 Parganas, which is within the jurisdiction of this Honorable High Court. But on this point, my lord, if my lord kindly permits me, I can place before my lord a division bench judgment.
They are not raising this issue. Why you are raising this issue?
Yeah.
So, my lord,
Issue of
kindly allow
territorial
me to
jurisdiction.
file the, my lord, ABDB in opposition, my lord. Because, my lord, this is a transfer bill. I have instructed that ABDB in opposition has been filed before your lordship.
So, my lord,
His liberty was given you long back. Thereafter, you didn't file, and hence Justice Kapoor says, "Okay,
Last
come with
occasion,
written notes of argument."
yes. And Mr. Justice Kapoor was pleased to hear the matter, and hearing was concluded.
In 2010, such liberty was given to file affidavit in opposition.
And, I have no knowledge because they transfer. Kindly, my lord, last chance, when I allow me 2 weeks time to file.
Okay, not this week. Let him.
Kindly
let
2 weeks, give him 2 weeks time because, my lord, my lord, ABDB in opposition requires some time, my lord.
No such time. It is not that you have got a right since you are state, you will go on getting time again and taken to file affidavit in opposition. Years after years. File it. On that date I said, file it, otherwise all the statement of the writ petition shall be accepted to be true, taking adverse inference against you. What do you think? Go will give time years after years to the state. You file affidavit in opposition, only you will discharge one duty, will come and pray for extension of time to file affidavit in opposition. Years after years. And it is going on. And going outside the court, it is you will say that numbers of cases are pending in the court. In numbers of cases, you have been given liberty days after days to file affidavit. Adjourn the matter 2 weeks. If you can file affidavit within that time, that would be accepted. Otherwise, you will not be accepted. Okay. 2 weeks. Adjourn 2 weeks. If the party wants to exchange their affidavit, they can do so in the meantime.
Now, then my lord fix a time for filing affidavit in opposition. But if he serves a copy of the opposition, then I can serve him a copy of the
Please,
reply.
2 weeks times again.
2 weeks for his opposition.
Opposition.
মানে
So that liberty was given in 2010 and the time which was given in 2010, today I am to extend the same. Okay, really good.
And my
the
lord-
learned advocate appearing for the
and my lord, kindly
appearing for the respondent pressed for extension of time to file affidavit in opposition to the writ petition. ঠিক আছে, আচ্ছা। Such pair has not been opposed by the learned advocate representing the petitioners. In view thereof, time to file affidavit in opposition has been extended to has been extended for a further period of 2 weeks. Acha, stop. Let such affidavit in opposition be filed within 2 weeks from date. Acha, reply thereto, if any, shall be filed within a week thereafter. List the matter 3 weeks hence.
and my lord, kindly record, no further extension
No.
would be given for filing affidavit.
They are prerogative to get years after years. Okay. Next.
31, I appear in the petition.
My lord, item number 31, Mr. Arindam Chattopadhyay is representing the state, my lord. My lord, with the assured evidence, he is out of station due to some personal difficulties. My lord, 1 week accommodation is paid, ma'am.
May I submit one thing? That is in respect of the postgraduate scale of thing. I can submit the written notes of argument by tomorrow. My learned junior will submit. Let Mr. Chatterjee, if it is there, if they want to file, let him file. Let it be. Otherwise, we do not know.
Mr. Chatterjee will not remain
2010 matter, we do not know. Now, he
in
can
this
inform.
week.
He can inform Mr. Chatterjee to prepare the notes.
My lord, it will be better with assured evidence if it is kept 1 week, my lord, after 1 week. Then Mr. Chatterjee would be here, man.
He is saying that he will file a
Written,
written notes of
my lord,
argument tomorrow.
my lord.
He will hand over the same.
My lord.
Thereafter, week will be given to you, either to respond thereto or
Yes.
To get yourself prepared on the basis of such written notes of argument.
My lord, that as your lordship.
So not today?
My lord.
কালকে তৈরি করে জমা দিয়ে দেবো।
32.
My lord, I am for the petitioner.
Tomorrow,
I am
first
appearing
half, after 12 or 12:30, I will be leaving. So first half is there. If your lordships keep it some precedent, so can I submit the
Okay, just it is exchange of written notes of argument. Submission of the written note of argument and exchange. Your junior will.
Well, all will be.
All will.
I justly I attend and thereafter I shall left. Some please. I am preparing
32.
My lord, I am for
31. এই 31 টা কালকে করে দেবেন তো ওই
even it to be mentioned, it can be placed.
To be mentioned. আচ্ছা. Are the learned advocate appearing for the respective parties? আচ্ছা, Mr. Bari, learned advocate appearing for the petitioner, press for leave to file a written notes of argument. আচ্ছা, by tomorrow, ঠিক আছে, as a list of argument, and he submits that the same is ready. Even he will be able to file it by tomorrow. ঠিক আছে? আচ্ছা, stop. In view thereof, list the matter. So list the matter. So let the matter appear
Under the heading
tomorrow under the heading to be mentioned.
Grateful. Extremely good.
My lord, I am appearing for petitioner on behalf of Phatik Chandra Das and for adjournment of 1 week.
1 week. Not this week. শেষ হয়ে যাবে তো লিস্ট আমার। আচ্ছা, পর্যন্ত ডাকুন, বাকিটা লাস্ট এসে করছি, তাই না? এইগুলো কালকে একজন, আজকে যেগুলো হচ্ছে কালকে একজনে দিয়ে দেবেন। কালকে এই গ্রুপ ডি চাইছে পার্মানেন্ট অ্যাপয়েন্ট পিটিশনার, পার্মানেন্ট অ্যাবজর্পশন চাই। আজকে নট টুডে করবো, কালকে এগুলোকে একজন যেগুলো ইয়ে হচ্ছে না, একজন হচ্ছে না, কালকে একজন হিয়ারিং হিসাবে দিয়ে দেবেন, নিন। অ্যাপয়েন্টমেন্ট চাইছে প্রাইমারি টিচার, 2009 ইন্টারভিউ হয়েছিল এগুলো।
Item number 47, both of us are here.
Item number
47, all of us are here. May I start now or after 2 p.m.?
After 2 p.m. Acha, none appears on behalf of the respective parties. ঠিক আছে। আচ্ছা, the matter relates to appointment to the post of assistant teacher, to the post of assistant teacher in primary school council. Under the primary school council in district South 24 Pargona, ঠিক আছে? আচ্ছা, records reveals that the selection process initiated in 2009 stopped. I am of the view that with the passage of time, passage of time, that petition has become entitled. Accordingly, the same is disposed of, dismissed, interim order, if any, stand valid. Okay, dismissed. আর কি 35 tomorrow করে দিন, এগুলো এই যেগুলো অ্যাডজন হচ্ছে না, কালকে ইয়েতে দিয়ে দেবেন। হ্যাঁ হ্যাঁ, অ্যাডজন হয়ে যাবে। কেউ ডিসিপ্লিন প্রসিডিংস কেউ নেই। ওকে, tomorrow দেখে দিন। একটা ডাকুন, এটা এটা নট টুডে। হুম, 36 এগুলো তো টাইম। এটা অ্যাপিয়ার করেছিল 23 লাস্ট। ওকে, নট টুডে, ঠিক আছে। আপ টু 36, ঠিক আছে, 37 থেকে
by hand.
Having regard to the submission made on behalf of the petitioner and upon consideration of the facts and circumstances, I am of the view that here presence of state representative is very much.
Well, the ECL representatives, ECL.
ECL is very much required for adjudication of the petition. Stuff in view thereof, petitioner is directed to serve a notice upon the respondent, giving an intimation that the matter shall appear at 2 weeks since.
2 weeks.
Matter shall appear 2 weeks since.
Grateful.
Up to date. Not good. Up to date.
And for the petitioner lordship, the same as item number 11.
42 to 46.
42 to 46. Yeah.
Okay. Oh, same going. 2 weeks.
Grateful.
Forty-seven, my lord. I am added respondent number 10, my lord. I have been added by your lordship's order, my lord.
For the petition.
Dated 3rd of April 2024. I am, my lord, representing Paschim Bongo Somogro Shiksha Mission, my lord. There is a state project director under it. My lord, my learned senior, sir, আমি একটু বলবো আপনার আগে একটা কথা। বসে পড়বো? আচ্ছা।
পরে বলবো,
The
সময়
state-
আছে তো?
আচ্ছা।
বসতে পারবেন, আপনি বলতে পারবেন।
But for the state, Mr. Arindam Chattopadhyay is appearing, my lord. He is out of station, my lord. I have beseeched your lord,
You remain.
my lord.
My lord, I am for the petitioner.
Yes.
The case relates to very short facts. Here is a advertisement, or I'm giving emphasis on the date of advertisement. 27 July 2007, you'll also can mark it, very important date. On 27 July, বসো না।
27 July.
কিন্তু পরে যছে
July 2007. Yes, advertisement.
বসো না তুমি। On 27 July 2007, advertisement was made by the district project officer, Sarvashikha Mission Nadia, Sarvashikha Mission Malda, for appointment of additional para teacher in a madrasa, in a high madrasa. Thereafter, on 15 January 2009, the persons concerned, eligible persons concerned, were asked to produce their academic attainments. From law is, guideline is, there will be no interview, no merit test, only on the marks attained on the examinations up to graduation level or post-graduation level, that will be created. Post is an additional para teacher in social science. Social science.
Yeah.
Competition held, marks are given by the concerned authorities. And entire process was regulated by the government coordinators. Here I top the list. I obtained 45.8 marks One Ruma Tokadar obtained 28.7 marks. One Sushmita obtained 38.45 marks.
Yes.
The panel was sent to district project officer. In the meantime, managing committee of the madrasa prepared separate panel. They produced a panel showing Ruma Tokadar top the list.
Yes.
The district project officer said, your panel cannot be accepted. You file a rectified panel. Then managing committee filed a rectified panel.
Yes.
That was sent for approval by the district project officer. At the district project officer was maintaining suspended elimination. I moved the writ court. And a judgment was passed by the court that to give me appointment. District social officer, local social officer, local officer filed an appeal. That appeal was allowed in part, only directing the officer to consider the panel in accordance with the law.
Yes.
That was considered according to him. I was aggrieved by that order. I challenged again. This is the writ petition.
Yes.
In this case, affidavit in opposition has been filed by the state government saying that my panel is correct. Empanelment where my name top the list is correct. But I cannot be given appointment on the basis of a ban published by the Education Principal Secretary. I will make submission later on. And that point is now to be decided by your lordship. And on that basis, my fate will remain to be decided. Now I place before your lordship competent. Kindly see, my lord. 45.
My lord, my learned senior friend, apart from the rejection order issued by the district project officer, my lord also challenged a policy decision of the state government where, my lord, this is dated 9th June 2010, that is at page 81 of the writ petition. By this policy decision, my lord, the state government, my lord, imposed an embargo, my lord, to appoint any further para teacher. Page 81.
Come
Yes.
to the point.
No,
I have not.
my lord, today,
I am
my lord,
not. I am not gone into the fact.
no,
that-
certainly not. My lord, it
I
will
am
take
not-
some time. My lord, we are, my lord, the implementing agency of the
Lord,
policy.
Let him argue, my lord.
Yes, my lord, we are
Let
the
him argue
implementing.
whatever he likes.
No, I'm just saying.
No, this is a very bad practice. In
No,
this
not
High Court now,
practice. I don't want to
and
waste
this
your
also
lordship's
was in the
time.
bar in this High Court.
I don't
A
want
very
to.
bad practice has been
No,
developed. in the
kindly
High
allow
Court.
me to finish.
They
But
are
I would
taking
like to.
government's,
I would like.
government money, only shouting before the court.
No, I'm
without
not
going into
shouting.
the point.
My lord, I would like to file an
This is very-
opposition, my lord,
I-
since I have been added last week.
Opposition later on.
My lord, if required.
To shorten the area of the litigation and to avoid any such a distance. If without going into the question of legality of imposition of the ban, or legality of the order whereby
Affidavit already filed by the state.
ban was imposed,
Already.
whether the said ban will be applicable in the given case or not.
But if, my lord, if your lordship,
Affidavit has been filed by the state, who is the appointing authority?
no, appointing authority is the
Yes.
district project officer, my lord, he is under me.
Your affidavit, then affidavit should be struck down. If my lord can say this affidavit is not the state government affidavit,
Well, that is,
let it be struck down.
this has to be clarified.
It has to
Okay,
be
okay,
struck down.
Let me hear.
Very
So,
good, very good.
If the
So what
justification
zealous?
of the act of imposition of the ban is required to be charged, touched by.
Well, yes, yes. If your lordship
Imposing on,
thinks it fit,
then
then
I
very
shall
good,
secure
very good.
presence of
That
the
is why.
state
Very well.
representative because before taking any decision.
Great.
Okay.
I am a grateful man.
Yes, proceed.
So what zealous? Very difficult. Now
No, no.
Supreme Court has said a government lawyer should not be overzealous. Kindly show, NSU.
No, fine.
I'll show 2000 Supreme Court tomorrow, next day. What is the function of a government lawyer? They should not be overzealous before the court. They have to assist the court. Truly and fairly. Now, my lord, kindly comes to
Yes.
this practice is developed in the High Court. I can meet this point, combat with them. If they come with fist and blows before the court, I can combat with them, no problem. My lord,
So the
now
ban,
kindly
I have got the order dated 9th June 2010.
Kindly, my lord.
By this order, the state government imposed a ban in giving engagement to the para teacher. Oh, okay. Now, when the selection process was started?
My lord, selection
to that.
process started.
Prior to 9th June 2010.
Prior to
9th June 2010.
2010.
2010.
No, to 27
So the
July
issue is
2007.
issue is that this order has been given applicability to a pending action.
That is one of the issues.
To a
Absolutely.
pending action. Now the issue is whether in pending action, this order can be applied or not.
Whether it can be given retrospective effect.
Issue certain.
This is the point, only point.
Now there is no requirement of hot altercation. Now go. Yes.
No, retrospective effect has not been given. Because selection process started on 27 July 2007. At
Yes.
that point, it was not born.
Yes, yes.
The ban was not, embargo was not born.
Yes.
How I can be affected by the embargo?
That is
That is
the
my humble submission.
dispute
I
right
show
there.
authorities on this point.
I have got
Yes.
the point. Dispute
Now, my
right-
lord, kindly see the order of the Honorable High Court.
Page.
My lord, kindly see page 65.
65.
Page 65.
Page 65 cost title, operative part. Long order.
Page 65, kindly see.
I direct the managing committee of the school to take resolution and to prepare a first panel as per merit list. Yes,
Page
page
60,
79,
page 79 and 80.
79, 80, operative
Correct.
part.
Thereafter, my lord, appeal filed.
Appeal file.
Thereafter, appeal filed. There is also some problem. Who filed the appeal? Kindly see. Appeal file. Kindly see, my lord. Who filed the appeal?
District Project Officer Malda.
Kindly see, page, I am showing a lordship. Page 114. District Project Officer, page 114.
Yes.
District Project Officer did not take any opinion from the LR. He filed the appeal on his own by engaging lawyer and spending money from his own pocket. Then the appeal court passed the order, page 129. Appeal court. At that point of time, I could not obtain the instruction from the LR. Now I obtained the instruction from the LR that the LR was not moved for preferring appeal. This district project officer, because my client was a very beautiful girl. This project officer was very much after her. She did not submit to his last. As such, he was victimized by this project officer. Kindly see order. He preferred appeal by this particular district project officer, one Chinmoy Sarkar. Government lawyer appointed with LR approval. This should be sent to the CBI. After hearing the learned advocates appearing for the party appeal process, the following direction issued by the learned trial judge are deleted. My lord, you will also have seen the order of the learned trial judge, 7980.
In this petition, district
79
project
bottom.
officer has been made party by
79
eight.
bottom. The district project officer on receipt of the same will grant approval. Last line, last.
Yes.
Page 79, last line.
Page 79.
79, last line.
Yes.
The district project officer, I not got it.
Yes, got it.
On receipt of the same will grant approval. The managing committee is directed to complete the process within a period of 10 days from the date of communication of this order by a letter to be issued by the learned advocate on record for the petitioner, and the district project office is to grant approval within a period of fortnight from the date of submission of such panel. Now, this particular part has been substituted by the appeal court. Kindly, page 139 bottom. Aforesaid direction of the trial court are substituted by the following order. The district project officer on receipt of the fresh panel shall consider the same in accordance with law and pass an appropriate order. Page 130.
113 is
30, next page. This is the substituted part granted by the appeal court. Page 130 top. After that, district project officer considered. Page 131.
Yes.
Same man who preferred appeal, same man. He is the appellant. He is the decision-making authority. He is all. Then, my lord, he said, what he said, kindly see.
Page 133.
Kindly see. Let's see. Page 132, fourth paragraph.
Yes.
In compliance with the order of the Honorable Division Bench, rectified panel submitted by the Madrasa Authority in compliance with the order of the Honorable Single Bench of the High Court, Calcutta, is taken for consideration. It is found that on 19/10/2011, Madrasa Authority has rectified the panel as per norms and placed Sahara Parveen at the top of the panel. I am the Sahara Parveen. This is his order. The panel is found justified as per SSA Sarvashikha SSA norms prevalent before 9/6/2010. Now the question of granting approval to the panel arises. This is his finding in my favor. Now what he says, suddenly he made the volte-face. It is clarified that, kindly see last line, page 132. It is clarified that there is no question of any appointment since the ban imposed by the state is in operation. Now kindly see the ban. Now kindly see the ban. I show you lordship, one after another. These officers, how he has filed affidavit, preferred appeal. He is no more in Malda. Either he has been promoted or something, or I do not know. But his house should be searched by the CBI. Page 81. He wanted my flesh. I did not give flesh to him. I've said so in my petition. Because this post of para teacher, it is just for female. Can you see government ban? Page 81. Yes. In continuation and partial modification of the memorandum, my lord, can you see who is issued? School Education Department. School Education Department cannot take policy decision. Only the cabinet is the competent authority. Your lordship has vast experience, your lordship knows. Under Article 162, 166, it is the cabinet can take policy decision, not a particular secretary. One secretary cannot take the policy decision of the government. Kindly see, he says the governor to make the following kindly modification of the aforesaid GO. No new engagement of para teacher or any other category of employees can be made after the issue of this order. When it was issued? 9/6/2010. Selection process started 27/7/2007. How it can be affected? I was selected on 2009, 15 January 2009. How it can be attracted? Now what happened in Lordship, can you see? These particular officers made a wrong statement in this case. Can you see? I am showing you, Lordship, the documents. Can you see, my lord, page 97, page, this should be sent to the CBI, page 87. Page 87, your lordship, can you see? This is a letter on 25th of July 2012. And the ban imposed on
June 10.
9/6/2010.
Yes.
Kindly remember this particular date, 9/6/2010. Now, this letter, can you see, this is issued by the Sarvashika Mission. On 25th of July 2012, on my RTI, they are supplying the information. Kindly see, 229 numbers of engagement letters issued to para teachers or any other employees after 9/6/2010, either issued by the court case or a special drive for LWE blocks of Bakura, Purulia, West Dinajpur district. Such information related to these para teachers who are available in this official letters. Para teacher appointment has been made. Various districts, can you see? Next page, page 88. This is Bakura. In Bakura, para teacher was given appointment 229. They say there is a ban. I cannot give you appointment. 93, page 96, my lord. 229. Thereafter, you will also can see another page 97. Again, Sarvashika Mission, Howrah. 12th September 2012. Information under SSM 96/2010 mentioned here, enclosed annexure or employees reports regarding engagement of para teacher or any other under SSM after 9/6/2010. I am giving emphasis the word after.
Yes.
After, my lord, kindly see after what? My lord has seen after page 97. As per your letter under reference received from the additional state project director, PBSM Sarvashika Saban SPIO Information Officer, dated 18 July 2022, 12, reports regarding engagement of para teachers or any other employees under SSM made after 9/6/2010 are enclosed herewith. After, who are they after? Can you see? Various persons, page 99 onwards. Various persons. Up to page last page, kindly next page 101.
Yes, up to page 112.
Then thereafter, my lord, another page 102.
Yes, up to page 112.
Yes. Page 102, another has been issued. Has been issued on Porsimid reports. Porsimid report, all 12. Then another. Kindly page 109.
Yes, yes.
109, 6/8/2012, after 9 June 2010.
2010, yes.
After what you will see, these word after is a very, very valuable word. After 9/6/2010, these are the persons. And the district project officer affirm an application before the appeal court. Kindly see. Kindly see. Very important affidavit. I do not know where he belongs to some ruling political party. District project officer is the appellant, page 114, bottom. Kindly see his affidavit, page 127. Page 127. Chinmay Sarkar.
Yes.
I am presently holding the post of district project officer. I have made myself only acquainted with the facts and circumstances of the present case, being duly competent and duly authorized to affirm on behalf of the petitioner. He cannot be authorized. It is the government policy, government decision. State government officer, what the officers, they are the parties, can you see? Parties are the government officer party. Can you see, my lord, page read petition, what the officers of the government, page 8 of my read petition, page 8. Page 8 of the read petition, can you see what the government officers? State of West Bengal, through the Principal Secretary, Department of School Education, then the district project officer, then the district magistrate and mission director, Sarva Shikha Mission, Malda. Then circle project coordinator. Then circle project officer, and he was made a party in name, Chinmay Sarkar. Now he has filed an affidavit now before your lordship. Kindly see his affidavit. Kindly see his affidavit. Chinmay Sarkar. He is after me. In the meantime, good luck is my client has been married to a particular Muslim. She is saved. She is also Muslim. She has been married to a particular Muslim. Kindly see affidavit in opposition filed by Chinmay Sarkar. My lord God.
Yes.
Kindly see affidavit in opposition. Page 7. My lord, kindly see. Very important. Affidavit in opposition to the writ petition on behalf of the state respondents. Paragraph 1. My lord got it.
Yes.
Paragraph 1. I am the respondent number 2.
As
Yes, I am
in the
well
capacity
acquainted
of
with the
respondent number 2.
I have
not
been
personally,
duly,
yeah.
I have been duly authorized by the rest of the respondent. Where is the authority? Affidavit of competency. Where is the affidavit of competency? Under the powers of Attorney Act, he has to file affidavit of competency under the rules. He has been authorized by the principal secretary. Where is the authority? As such, he has made a wrong statement here. Then, my lord, kindly see his page 7. Page 7, kindly see. Appointment of Sunita Jadhav mentioned in paragraph 22 of the writ was made by the WEC authority under the contempt proceeding at High Court at Calcutta. Rule was issued, matter mentioned in paragraph. High Court passed order, appointment issued. They did not say that there is an embargo. Then High Court cannot pass an order in contempt proceeding. Can you see? Another person has been given appointment, Sunita Jadhav. I have given the name particularly. Then matter mentioned in paragraph 23 of the repression, the letter issued to the authority, Bengal High School in Southern prior to school authority at that point did not follow the order. Later on, they gave appointment following honorable court's order and rejection of appeal by the honorable division bench. Honorable division bench rejected their appeal also, government's appeal. Why should be treated discriminatorily? Why I should be excluded from the same consideration? The matter of approval of that appointment has not yet been finalized by this end, is now sub judice. By this end, Manoj, that means these project officers. Then kindly see page 12. Page 12. Yes. The order of petitioner was modified in the appeal court, while the matter of Abdul Kalam Azad has to be complied with under the direction of contempt court pending decision of the appeal. Same learned advocate was contesting 2 cases. It is further to mention the case of Abdul Kalam Azad, who was disposed on the strength of the order. It was challenged, so the allegation of discrimination is not denied. The judgment taken recourse to the district project officer, SSM, in the order under challenge in this writ petition are all order of honorable court forwarded by the state. Then, my lord, district project officer SSM, he has categorically admitted. Kindly see, this is very important. Or these particulars. There is no question of malafide exclusion. In the order passed by the district officer, SSM Malda, it has categorically been admitted that petitioner deserved to be appointed. My lord, got it? Has the ban such and such not been in position, so the panel cannot be considered on the following grounds. I will not read these following grounds. Kindly see how many persons have been given appointment. Page 15. He has given the names. These persons are given appointment. Then, my lord, page 22. The second paragraph. The appointment referred in the other district is matter of fact can best be answered by the respondent district authority. Special permission was accorded by the department of LWE affected districts. Special permission was given, he said so. I do not know what is the document. Presently,
Page you are reading from page?
Page 22, second paragraph.
Yes.
The appointment referred in the other district is matter of facts can best be answered by the respective district authority. Special permission was accorded by department for LWE affected districts. Presently, SPO, PBSM is even moving to Supreme Court in different cases in different districts to save guard of 9/6/2010. What happened to the Supreme Court, I do not know. Let them say. Sarvashri Commission is here. They will give the answer to your lordship. What happened to in the Supreme Court? My lord Gandhi has made a wrong statement, page 24, bottom. It is also not bottom.
Yeah.
It is also not true that the state government is allowing other district to proceed with the appointment of the para teachers. How he can say? Similarly placed district project officers are giving appointment to the selected persons. Who is it to say? He is so overzealous employee of the government, purchased by somebody and to imbibe somebody to get the favor on his shoulder. Now he has been promoted. This person. Then, my lord, page 29. This is the government. One. Page 29. Page 29, 30. Passed by him. This particular Malda district project officer. Now relevant portion is, relevant portion I will show from at the present moment with regard to my affidavit in reply. Kindly see my lord affidavit in reply. Paragraph 3. I've taken the point. Then I will argue on the government, the constitution here. My lord, kindly see my affidavit in reply. Paragraph 3. With reference to paragraph 1 of the affidavit in opposition, I said that this is an affidavit filed on personal behalf of Chinmay Sarkar, not on behalf of the state respondents, namely Principal Secretary, Department of School Education, District Magistrate, and Mission Director, Sarvashika Mission, and Chakra Prokolpo Coordinator, Chachol, moreover, it is not an affidavit on his personal person, as he has been implemented his name as respondent. He cannot, my submission in this case, I say that since he is the person, he has been implemented in name, in person, he cannot file affidavit on behalf of the state respondents. He has to file affidavit on his own, not on the
Now,
state
yeah,
respondent.
Mr. Bhattacharya, without asking the court to consider this aspect, or regarding the personal allegation against the person, if we all confined with the question that whether the ban can be
Personal
applied
allegation,
in
personal
this
allegation,
pending,
I follow.
in pending selection process, or
No,
not,
personal,
answer will come.
personal allegations I have stated before your lordship to take it to the judicial notice of the honorable court. Who is the killers? For such reasons, I have referred to the personal allegation. But with regard to law,
It is a matter.
with regard to law,
It is a matter of fact that that apart is a mental state or motive lies in the mind of that district project officer in his personal capacity. That motive or intention can be
reflected on me,
hard to.
reflected on me by in his order. He passed the order in terms of the division bench against me that the approval cannot be given. His mind has been reflected. That is, malice has been reflected. Maltree has been reflected. This order I am challenging before your lordship. With regard to ban,
Actually, if we confine ourselves to the question that whether the ban can be applied in the present selection process or not.
My submission,
That will, yeah.
my submission
Because
before your
the
lordship.
first portion you have got the relief that you are entitled to get the job had there been no ban.
Correct.
You are entitled. It has been proved. Now, without going into the personal attack against the person concerned, if we consider confine
Now now I am limiting my submission before your lordship.
Yes.
Advertisement started, published.
In 2007, yes, I have got. Ban came in 2008.
And this particular policy decision or the
was taken
embargo
yes,
is prospective. It has not been
yes.
given retrospective effect.
Retrospective.
As it does not apply to me.
Yes.
The advertisement will continue to apply on me.
Yes.
I am a beneficiary of the said advertisement where I have been selected and the district project officer said, I am also selected, I have become the top. So why my appointment should be?
Withheld. Okay.
Two judgments I am showing.
Yes, yes, two judgments.
Kindly see paragraph our High Court judgment, Supreme Court has been dealing. 2007, Volume 3, CHN 545.
545.
5.
Yes.
545, paragraph 16 and 17. A point came up with regard to School Service Commission, what division may say. It is not in dispute that the provisions of the West Bengal School Service Commission Act 1997, the rules framed thereunder have no retrospective effect. Therefore, the process of selection, if initiated prior to coming into force of the West Bengal School Service Commission Act 1997, rules framed thereunder, then the said selection process cannot be affected by the provisions of the Act rules framed thereunder.
Yeah.
Therein also. Of this particular judgment, where a judgment has been referred to, Snehangshu Josh. Kindly see, 2001
yes.
volume 3, Snehangshu Josh. The Snehangshu Josh matter, I argued on behalf of the appellant. In that case, the Chief Justice Mathur and Justice Girish Gupta, who became the Chief Justice later on, held that this ratio, the ratio in 2013, which I referred to your lordship, 2007, has been borrowed from the judgment of Snehangshu Josh. Kindly see where I argued the matter. Page 36. 2002 WBLR, Calcutta, page 36, paragraph 22. Yes, paragraph 16 and 22. Where I had the privilege to argue for 7 days to settle the issue. This is for the purpose, the issue was settled on this particular judgment first in the Honorable High Court. Yes. Yes, Mr. Mukherjee.
My lord, in the instant case,
You are for? For the managing committee. Yes. Yes, yes, yes.
my lord, will kindly take only 2 pages
Hmm.
from the writ petition, which is part of the order of the honorable single judge, which was modified.
Yes.
At page 78.
Yes.
Please say the last paragraph on that page. Heard the submission of the learned counsel for the respective parties and considered the materials available on record. After a scrutiny of the letter issued by the district project officer on 27th July 2007, it appears that the requisite qualification is BA only. The combination of subjects as notified by the school authorities are not at all the requirement. Therefore, the requirement is not in consonance with the aforesaid letter and is not the criteria for the selection. It appears that the concerned coordinator has prepared the panel as per the merit on the basis of the marks secured. It appears that the writ petitioner has secured the highest marks and accordingly the coordinator has placed her at the top, but the school authorities in clear contravention of the circular of 27 July 2007 have prepared a panel which is unlawful and not acceptable and are not justifiable on the basis of the aforesaid circular issued by the district project officer. So far, the submission made by Mr. Bhattacharya, the learned counsel for the state, is concerned, the submission are all contrary to the letter dated 27th July 2007. The argument advanced by Mr. Ghosh is also not justifiable. The combination of subject is not the criteria for selection of para-teacher in social science group. In my opinion, the chart or panel prepared by the circle project coordinator, which was sent to the district project officer, as well as the school authorities prepared in terms of the aforesaid letter and also guidelines, fulfill all the criteria for such selection, and the managing committee should be directed to take a decision on that and to submit the same before the district project officer for approval. I direct the managing committee to take a resolution and to prepare a fresh panel as per the merit list prepared by the concerned coordinator and to send the same before the district project officer for approval. The district project officer on receipt of the same will grant approval. The managing committee is directed to complete the process within a period of 10 days from the date of communication of this order by a letter to the learned advocate. But I have acted in terms of this order. But what was the modification? Please see the modification by the division bench at 129.
Yes.
Should I skip over the first two paragraphs? It only quotes the date of the order and the operative portion. Please take the last two lines on that page. The aforesaid directions of the trial court are substituted by the following order. The district project officer on receipt of the fresh panel shall consider the same in accordance with law and pass an appropriate order. Now, two things stand out clear. The order passed by the Honorable Single Judge remained untouched in so far as the illegality committed in unsettling the settled proposition is concerned. The direction was modified. Now, please come back to that particular page, not 77, once again, not what has been held by his lordship.
That means other portion of the order has been left untouched.
The direction stood replaced or substituted. Now, when his lordship at page 78 and 79 held that the panel prepared suffered from a subsequent illegal act, then removal of illegality would relate back to the initial date.
Yes.
I cannot be made to suffer the brunt of an illegality committed by a state. State today cannot say that I have acted illegally. Now something has stepped in, therefore you should be deprived. My right flows from the rectification of the illegality which was supposed to be done in 2007. So the right had crystallized long back on 27th July 2007, and the so-called ban
Yes.
of 2010
Yes.
would not operate in my case. This was how your lordship was pleased to frame the issue while hearing my esteemed senior friend Mr. Bhattacharya.
Yes.
Now, please, coming back to the language of that so-called ban at page 81, please see what was the purport of this order. 9th June 2010, page 81.
Yes.
In continuation and partial modification of the memorandum, dated 23rd April 2010, the undersigned is directed by the order of the governor to make the following inclusion or modifications in the aforesaid GO. First is admissibility of certain allowances, enhancement 5% of the remuneration. 2, these persons will remain engaged till they attain 60 years of age. Numerical 2, no new engagement of parateacher or any other category of employees can be made after issue of this order. Now, this was really modification of a 2010 situation, but my right would have crystallized, and actually it received the stamp of validity by reason of the Honorable Single Judge's order apropos the 2007 panel. It's not creation of a new panel or creation of a new right, something like that. An illegality was perpetrated, which has been rectified by this court. Now, please come to some certain.
Now, your right to get a service of parateacher. Yes.
Now, the sole ground on which this right is sought to be negated is this ban.
Yes.
I can show at least 10 examples. I just indicate the page numbers. Now, there is the supplementary affidavit of the writ petitioner in connection with the writ petition. It runs from pages 84 to 108 of the writ petition of this document. I mean, compilation before your lordship. It's a supplementary affidavit. Just to show the averment at page 84.
Yes.
At the time of hearing of the stay petition, it was submitted by the learned advocate appearing for the appellant that no appointment to the post of para-teacher has been made after 9th June 2010, being annexure P3 at 87 of the stay petition. Upon collection of records, it appears that the statement made by the district project officer and the learned advocate appearing for the district project officer who was present in course at the time of hearing is not correct in view of the following documents. From the information supplied to me by the district project officer on 25th July 2012, under the Right to Information Act, it appears that many para-teachers have been appointed after 9th June 2010. Now, please take only one of the instances at page 111.
Yes.
The information sheet on the basis of available records at this office is prepared and given hereunder with response to your appeal under RTI Act, which forwarded by ASPD, PBB, SSM and SPIO with a memo aforementioned. Please turn over the page.
Yes.
Name and address, Shitol Chandra Das, memo number so and so, date of joining 14/7/2011, category para teacher. Posting place, Uttor Koltola Primary School. Condition of approval, court case in place of Srikanto Sarkar. Similarly, if this can be done for other persons, why not for the petitioner who had an accrued right in 2007? Another example, only to show that this was not, this was in terms of a court's order. Now to show an instance where appointment had been made bereft of court order. Please come to page 102.
Yes.
In response to your application dated nil, which has been received on 2012 through the additional state project director with a memo number so and so, the relevant information is hereby shared. Not each of the dates not mentioned in column number 3 not is post June 2010. And this does not refer to any court case because the last column is condition of the approval by the court or normal. The column says normal.
Yes.
So to pick out one particular sentence from that 9th June 2010 memo and to say that no, ban has been imposed by the state and therefore there can be no looking into any further. Now, this is probably a misreading of the document because that document itself was once again modifying certain terms and conditions.
Okay.
And the law is too well settled that an administrative action can only have a retrospective effect if it confers certain benefits. Now, that's the ABCD of administrative law.
Yes.
If a right is sought to be adversely affected, then the same can never have a retrospective effect.
Yes.
I demonstrate by way of an example. Say pay revision or career advancement, any one of the two. Not pay revision 2019 with effect from 2016. Could this be reversed? If on law is also well settled that on revision pay may not be upgraded, it may also be reduced. But could this be revised retrospectively so as to oblige an employee to pay back something to the employer?
Yes.
So this is one of the glaring instances of violation of Article 14. And therefore, my action taken apropos the Honorable Court's order is at page 150. That is the resolution in terms of the Court's order.
Yes.
These are my submissions.
Well, the answering respondent is the state.
You forget about the challenge.
My lord.
You forget about the challenge. Don't try to shift the responsibility upon the shoulder of the state.
No,
You
no, I
forget
will
about
also answer, my lord,
Don't
this,
come to
because
the-
this is
now-
my scheme. I tell your lordship, this is my scheme. My lord, in 1999, 2000, my lord, the central government introduced this scheme, Sarva Mission. Now, the object behind this scheme was, my lord, to spread education amongst the children who are between 5 to 14 years. Now, initially, my lord, the fund, my lord, the central government decided that 80% they will provide and 20% will be borne by the state government. Thereafter, my lord, it was reduced to 60-40. So 60% central government, 40% by the state. Presently, that is the ratio. Now, when it was introduced in 2001, initially it was the term of the employment was for 1 year. So, my lord, there was an agreement and the appointing authority was the school. So there was an agreement between the school authority and the incumbent. It continued for 1 year, and thereafter, if, my lord, if it is found that the performance is fine, or if there is a requirement, then again a fresh agreement was executed. Now it continued till 2009. In 2010, my lord, the government decided, prior to that, before this decision, my lord, on 1st of April 2010, Right to Education Act came into effect and the entire scenario was changed. Earlier, my lord, there was no compulsion with regard to qualification, pupil-teacher ratio, infrastructure, setting up of toilet, etc. The moment, my lord, the Central Act came into effect on 1st of April 2010, namely the Right to Education Act, my lord, there was, my lord, some obligations on the part of the state, there was some obligation on the part of the central government as well as the school authority also. So, my lord, at the relevant point of time, there were almost more than 1 lakh para teacher who were appointed. Now it has been reduced to 95 to 93,000. Now, in 2010, my lord, the state as well as the central government found that it is very difficult, my lord, if we, my lord, to implement the RTE Act if we do not take proper measures. So this is one of the reasons when, my lord, this is one of the reasons, my lord, this 9th June 2010 was introduced. There are 2 reasons. One is, my lord, the state by this notification enhanced the emoluments. Second, the state also decided that the retirement age will be, my lord, till 60 years. The third one was that this embargo, that there will be no further appointment. Now, this was done, my lord, in order to maintain the pupil-teacher ratio. That was, well, at the relevant point of time, there are, my lord, more than the number of teachers were more than the ratio. Now, this is one aspect of the matter. Secondly, my lord, in 2007, when this selection process was initiated by the school authority, my lord, the panel was prepared on 13th of February 2009, much prior to this embargo.
Yes.
Now, my lord, your lordship knows, my lord, if the rule is silent, either the service rule or any other rule, my lord, the validity of a panel is for 1 year, unless the rule says otherwise. So, my lord, the panel in a normal course expired on 12th of February 2010. That is even, my lord, much prior to 9th June 2010 circular. In any event, my lord, there are 2 aspects, my lord. First is, my lord, when this notification came, the Honorable Division Bench directed the DPO, my lord, to consider it in accordance with law. DPO took up the issue and found this 9th June 2010 ban. Now, my lord, my lord, perhaps he had acted in accordance with law. My lord, I do not think he has any malice towards the petitioner. He tried to protect the interests of the state. Now, my lord, the moment, my lord, this circular came on 9 June 2010, at the relevant point of time, my lord, there are several selection process and there are two circulars, my lord. I shall, if your lordship grant me leave, I shall produce those circulars. In those circulars, my lord, the state clarified that what will happen in respect of those selection process where my lord, no one has been appointed, but selection has been concluded. And a cutoff date was given that you have to appoint or conclude it within such time. Now, many school, my lord, concluded that selection process within such cutoff date. Many school failed. And my lord, there are instances, my lord, admittedly, that several school authorities, my lord, in violation of 9th June 2010 and beyond that cutoff date, appointed the empaneled candidates in violation of this circular. Now, my lord, when the Sarva Shiksha Mission or the state project director found this, my lord, there is one setup, my lord, let me explain this. My lord, this scheme, which has been framed by the central government, namely West Bengal Sarva Shiksha Mission, every state has a scheme, like Mizoram Sarva Shiksha Mission, Uttar Pradesh Sarva Shiksha Mission. Now, in West Bengal, there is a scheme, namely Paschim Bango Sarva Shiksha Mission. The state project director, who is an IAS officer, he is the highest officer of the state. He is, I will say, he is the trustee of that scheme because he has to deal with the entire money, he has to implement the scheme. And in each district, my lord, there is one district project officer who is also the ADM. My lord, he is ADM as well as the district project officer. He discharges the duties of the Sarva Shiksha Mission apart from his duty as ADM. Now, when, my lord, when Sarva Shiksha Mission, Paschim Bango Sarva Shiksha Mission found that the school authority, who were the appointing authority at the relevant point of time, my lord, indiscriminately or in violation of 9 June 2010 appointed many teachers, many empaneled candidates, although candidates, my lord, were not at fault. My lord, there was further a circular came and the district project officer became the appointing authority. My lord, I shall also produce that if your lordship permits me. So there was a sea change at that relevant point of time. At the moment, my lord, the district project officer became the appointing authority and the approving authority, my lord. This number of, my lord, I will say these are all illegal appointment. My lord, this is in violation of this 9 June 2010. My lord, the number was reduced. There are another number of cases, my lord, where suppose a writ petition was moved prior to this 9 June or even immediately thereafter. And my lord, it was disposed of sometime in 2011, 12, 13, then appeal the Supreme Court. And my lord, then contempt was filed. And my lord, in terms of the order passed in contempt or my lord, order passed by the Honorable Supreme Court or this Honorable Court, my lord, the authority, my lord, compelled to give appointment. There are also a separate case, a number of cases are there. But in any event, my lord, this the second set of cases, my lord, which my learned senior friend Mr. Mojumdar cited, that there are cases, there are normal cases that appointment has been given in spite, although there was no court order. These are mainly, my lord, this mistake, I will say, my lord, was done by the school authority. And in many cases, my lord, we have rectified, we have cancelled, although these were challenged again, but we cancelled many appointment letters. Now, these appointment, my lord, one cannot say that we have a right because these are, my lord, admittedly in violation of 9th June 2010. One cannot say, one cannot cite, my lord, a negative equality, which is not permissible. That there is a mistake on the part of the school authority or the district project officer in Malda or Murshidabad. Therefore, kindly extend that benefit to me also. It is not permissible in law. The moment, my lord, 9 June 2010 came, it was, my lord, applicable for all My lord, mistakes were committed by some of the officers, some of the school authorities, but mistakes are mistakes. It should not be perpetuated, should not continue. Now, there is another aspect of the matter. Today we are in 2024. My lord, today, my lord, there is another case, my lord, I will give judgment, orders, pending case, orders and, my lord, reference. Today, there are 93,000 para teachers in West Bengal. They are getting some between 15 to 20,000 salary, or say 25,000. Now, every year, my lord, we produced all records. Every year, the central government, my lord, reduced, my lord, their fund. There is one project approval board for this. The project approval board, my lord, has been set up by the central government. The project approval board, my lord, decided that what amount should be released. But, my lord, in violation of that, my lord, the central government reduced their fund. Therefore, my lord, today, Paschim Bongo Sarva Shiksha Mission or other missions also, my lord, are unable to, my lord, pay proper salary for these teachers. Now they filed a writ petition. Court said, why you are not giving? We said that this is the situation. Central government is reducing their 60%. This case is pending. And because of this 93,000 who are, my lord, they will continue and they will, my lord, retire sometime in 35 or 40. My lord, we cannot terminate them. Now, there is a heavy burden, financial burden on this, on the state as well as definitely on the central government. But that is not the only issue. My lord, a relevant issue is today in 2024, whether that madrasa, my lord, there is any requirement of that teacher or not. That is very relevant, my lord. Whether today in 2024, whether this school requires any teacher after 14 years. The school, my lord, is supporting the petitioner very well. But why, my lord, the school has not said that no, we are, my lord, on dearth of teachers, this one teacher is required for the betterment of the students? There is no statement on this. Therefore, my lord, an impaneled candidate does not have any indefeasible right to be appointed. This is, your lordship knows, my lord, this is a very well settled law. My lord, an impaneled candidate, my lord, cannot say, my lord, give me appointment. It is the discretion of the employer. And after 14 years, my lord, the employer has every right not to appoint any teacher, because I do not require any teacher after 14 years, because it has been, my lord, not required. If it is not required, why should I take that burden on me? This is a public exchequer, my lord. Everyone's money. So this is another aspect. Now the last aspect is, my lord, should be applicable, which was prevailing prior to 10th June 2010, 9th June 2010. If I admit this, that very well, the law prevailing prior to 9th June 2010 should be implemented, then at the relevant point of time, the term was for 1 year. I cannot, my lord, take advantage of one portion of that circular and shall challenge the other portion. That is not permissible. One is cannot blow hot and cold at the same time. There is, this circular says one will continue till 60 years. The same circular says ban and no appointment further after this date. So I will take the first one, take advantage of this one, and I will say that no, the other portion of that circular is bad in law. My lord, this is not permissible. If your lordship, my lord, allows this writ petition, then the law prevalent on that date prior to 9 June 2010 was for 1 year. And my lord, your lordship, the relief should be restricted to only 1 year and not more than that. Otherwise, this will be a burden on Paschim Bongo Sarva Shiksha Mission as well as, my lord, the state as well as the central government. My lord, these are my submissions, my lord. My submissions are based on 2-3 circulars. If your lordship give me permission, my lord, I can produce this circular. Although, my lord, so far the point of law your lordship has raised at the threshold, my lord, I think, my lord, these are my answers, my lord. If any clarification.
Actually, court wants it is get answer from you. We are here
Yes.
to defend the order passed by the district.
My lord.
project office.
My lord.
We generally prevent anyone to uh, say anything. You have the temptation to say how it was introduced and such and
My
such.
lord, I have just clarified the
but
background.
here your only duty confined to defend the order of the district. project
Absolutely,
officer.
absolutely.
In the order of the district project officer, he has admitted, rather in affidavit in opposition also, he admitted that yes, the candidate is deserved to be to come at the top of the
Yes,
panel
yes.
and deserved to be appointed. But due to ban, no appointment can be given.
This is absolutely correct, my
Absolutely.
lord. Absolutely correct.
Now, so your stand is that this ban will also be applicable in pending selection process. It is
My
your
lord,
stand.
my lord,
Okay.
yes, that is one of my stand.
It took much more time. Today,
My lord,
order
today
to
there is-
have been passed.
My lord, I think state should address your lordship on the next date.
Mr. I led by Mr. Due to emergency, he left the court, my lord. That's why problem.
How in this? Once the matter hard, it cannot be. Then again, so come today, tomorrow,
My lord, no
Huh?
problem, no problem.
tomorrow, yeah.
He will argue the matter, his part, my lord.
One submission I make.
Yes.
Whatever has been submitted by my learned friend with regard to
Mr.
lifetime.
Mukherjee or Mr. Mojumdar?
মজুমদার মিস্টার
Mr. Mojumdar or Mukherjee?
Mr.
Mukherjee. Yes.
His argument with regard to lifetime of the panel.
Yes.
But in the order,
Let's forget about the lifetime of the panel. That
no.
answer has been given.
in the order,
You say that engagement only for 1 year. He is saying engagement only for 1 year.
this is not correct in as much as in the judgment passed by the trial court, Justice Dash Adhikari as the lordship then was, this lifetime was not mentioned. It was open selection. And before the appeal court, in 2013, appellants did not say the panel has expired.
No, that point has not been taken.
So now the argument which has been made
Cannot be accepted.
by the Sarvashik Commission, not the state government, is not correct and true. I will show one judgment the next occasion or whether the state government officers, lawyers should make correct statement before the court of law. They should not mislead the court.
I have not misled.
Yes.
This is a point, this is a question of law.
Misled the court because
No, certainly
up
not.
to 2013,
Kindly do not say
they
all
have
these things,
not
sir.
ushered any war with regard to lifetime of the panel.
Panel is for 1 year. If the
No.
rule is silent, that is a settled law.
This is not
I
about-
also cite judgments.
No, this is not for 1 year.
Very well.
Open
I shall
selection.
also cite
Open
judgments of
selection.
Supreme Court, my lord. If the
Open
rule is
selection.
silent,
We
panel
know that.
should be,
We
my lord,
know
valid
Supreme
for
Court
1
decision.
year.
We
That is a
know
well
Supreme-
settled law.
We know Supreme Court decision because unless.
We have learned
lifetime-
from my learned friends.
Lifetime is not mentioned by them. This is open selection.
No, you have given you have rendered a decision which is really tough matter in legal field also. Whether a amendment, modification or new act will affect the pending action or pending proceedings or not.
My lord,
It's a tough matter.
very difficult.
Your district project officer, he has taken decision the same. He didn't seek any advice from any
Any other higher authorities.
any other higher authority. State has the legal.
My lord, I will, my lord, subject to your lordship's kind correction, my lord, I will, my lord, interpret in this way. When the circular says no new appointment, that means no new appointment with effect from this date. That means even if, my lord, the panel is prepared,
Even if the panel is prepared, one cannot appoint him unless the appointment has been issued on 8 June 2010. Therefore, my lord, I can initiate a proceeding, I can issue advertisement, I can, my lord, hold interview, then I can prepare a panel. At this stage, even at this stage, everything will be nullified. Because from 9 June 2000.
Mukherjee, you are also saying so. Your
My lord,
district police officer has said so.
my lord,
That
I-
is, can
my lord,
be.
my lord, today,
Okay, I am giving you some tasks for today. In any piece of legislation, if the legislature says no degree shall be passed, then whether it will touch the pending suit.
pending suit, my lord, cannot. Pending suit cannot touch, subject to, my lord, I have
Okay,
to.
you come to another. No tenant shall be ejected. Whether it will touch the execution.
No, unless expressly said
Whether
retrospectively.
it will touch the execution proceeding.
No, certainly not. Certainly not.
Okay. No degree shall be passed in a proceedings filed or pending at the commencement of the act. Whether it will touch the pending proceedings.
My lord, on that date, my lord.
Or whether it will touch the degree which was already passed.
My lord, if the decree is passed, my lord, it is a valid decree.
Complicated matter, Mr.
Complicated, my lord, certainly.
Whether it will touch the SLP which has been, where leave has been granted.
No, on the date when the decree was passed, on the date when the decree was passed, law was otherwise. Law was otherwise.
But if the legislature says that no person shall be ejected in execution of a degree and otherwise, then it will cover all. It's a complicated subject of
Yes,
legal
yes.
field. Your district project officer, if he feels any difficulty in giving answer to, he sought for clarification from LR departments. Okay, whether a subsequent amendment, whether any enactment, if given effect to during pendency of a pending proceeding or pending action, what will be the implication?
My lord, according to my understanding, my lord, the accrued right cannot be taken away. That is very well settled. Accrued right cannot be taken away. But my lord, the right should be restricted to 1 year also, because that was at the relevant point of time, that was his right. Not, my lord, 60 years. That your lordship kindly consider
So
also.
your Chatterjee is to be given
Yes, my lord, I will-
opportunity of hearing.
I will inform.
Otherwise,
Yes, yes, my lord. Tomorrow-
ওটা কাম এই
Tomorrow-
কালকে এটাকে টপে দিয়ে দেন তো,
I'm extremely grateful, my lord. But your lordship has vast experience and knowledge, therefore, my lord.
No, I am saying you should not say so. One administrative officer, he has said so, but you should be sure. It is a difficult question, difficult subject, and critical subject. I am giving some example to you in this way. Whether even if it is said no degree shall be passed, no person will be rejected in any pending proceedings, in any proceeding, filed or pending, whether it will affect the SLP. It's a vast subject. You take that task, come tomorrow.
My lord, hard in part, my lord.
Next matter, you have taken resolution.
No, Lordship, remembers, is that matter the Asha Karni, my lord? Lordship, heard out the matter on 5th of January 2024, my lord. About to pass the
Order.
Order. Then they
Sir,
took
hard in part,
2 days
sorry.
time to bring some documents. Till date, nothing has been. I mean, neither I have received any copy, nor I.
My lord, in this matter, I am the petitioner, my lord.
Already been heard out.
Who matter?
Let me.
Come tomorrow, come tomorrow.
My lord, may I only
lord,
one thing?
Just 1 second, my lord. I am praying for not this week in this matter because I will supply the record which I have collected.
What record you supply?
My lord,
Order-
I will file a exception to the report. I will file a affidavit of exception to the report. Only 4 days, my lord. In this week, there are only 4 days. Next week, next Monday, I will file the report, my lord.
Again, when Lordship will sit.
Positively, I will file, and thereafter, why he is so hurry? After 14 years, why he is so hurry?
No, 3 months long.
Only long 3
could
months,
not-
only
they
4
could not
days,
get
my
any
lord, only 4 days. Next week, any day fixed, my lord, except Thursday, my lord, any day fixed.
Okay, so.
My lord, any date fixed?
Not this week, 37, not this week.
My lord, may I?
And
And
my
my lord, I'll file the affidavit in
Lord,
exception, my
kindly
lord.
make it hard in part, my lord. It is a joint prayer, my lord.
Your lordship had, my lord.
Mr. Mojumdar?
My butter,
হ্যাঁ
candidate is butter.
Kindly make it part hard, my lord.
আচ্ছা তাহলে অর্ডার লিখে নিন আর দ্য লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং ফর দ্য রেসপেক্টিভ পার্টিস ঠিক আছে আচ্ছা লিস্ট দ্য ম্যাটার ফর টুমরো
Tomorrow.
Day after tomorrow, my lord, because
Day after tomorrow holiday.
Oh, day after tomorrow. Friday?
Eid.
Tomorrow, otherwise it will be only holiday.
No, if it is a, my lord, if your lordship keep this matter as a hardened part, my lord, it can be taken up any day. Your lordship, Monday
No,
or
Monday,
Friday, my lord, Friday.
Monday division bench will see it.
Friday, sir, Friday.
Monday division.
না ফ্রাইডে বলছি
So tomorrow, তুমি কেন ও বলবে তো? তুমি তো বলছো না,
Friday or-
tomorrow বলো, kindly take it up tomorrow. তোমার তো বলা হয়ে গেছে।
That advocate has gone, yes. So tomorrow, since
Very well.
I have
Very well,
stood
very well.
in front of that
Yes.
junior of Mr. Chatterjee.
Yes, yes.
Thank you. Had the learned advocate appealing for the respective parties, list the matter for further consideration on tomorrow, on 10th April 2000. Stop.
Great.
On the pair of the learned advocate appearing for the respective parties, let the matter treated as a part, hardened part, since this court has heard the matter substantially.
Great.
But since the, yeah.
My lord, the next matter, my lord, he is
Yeah,
asking for 1 week time, my lord.
Not this week, what this?
Not this week.
Some order may be passed, my lord, in this. I was waiting for a long time. My junior is.
Had the learned advocate appearing for the respective parties, I think,
Next matter, next matter.
list the matter for further consideration 1 weekends.
Much.
এই একটা কাগজ দিন নামটা দিয়ে দিন